Just give a couple of minutes. I don't see Sarah on. I don't see anyone else. Well, I don't know if Sarah's going to join us or not tonight, but do need her for some part of the agenda later, so I hope she gets on. So I'd like to welcome participants to the virtual planning board meeting of April 11th. So I'll now do a call to order. Ms. Creighton. Absent. Ms. Delicio.
Present.
Ms. Foley.
Here.
Mr. Gilbert.
Here.
Mr. Olney.
I'm here.
And Ms. Tenney.
Here.
Thank you all. It looks like we have a quorum tonight. I'd like to remember all board members, guests to ask to be recognized by the chair if you wish to speak, and this meeting's being recorded. First item on the agenda is acknowledgement of several documents the board has received, and they're all listed on the agenda.
Ron, this is Mary. Can I ask an administrative question on these?
Yes, ma'am.
I can list through, but there's half a dozen items that correspond. So something might be listed on the agenda as correspondence, but it's not in the folder, or we have items in the folder that aren't listed on the agenda. So like it says, the planning board got a letter of support from the open space and rec plan, but it's not in the folder. We've got two correspondence from residents, one from Lorraine Iavani about the open meeting citizens right to vote, and one from Sheila Hill, request for public press policy, and those weren't listed. So I'm just kind of.
They were, yeah, well, on those two, they were sent to every planning board member, so I didn't see any repetitious to put it in our meeting packet since you all received it. So that's why I didn't cut them in there. The others, I don't know, Sharon or Sue on the open space, or the other items where they put in our folder.
I would agree, you don't have to put it in the folder, but I think it should be on the agenda as correspondence.
Ron, I had Sharon said she had to put the letter in there. I didn't have a copy of it with your signature. I have it without it. So I'm happy to put the one that's not signed in there. It was voted on previously, so.
Okay, we'll get that done. Okay, before we go on, I'd just like to take a moment to express my support for our town planner, Sue Brown. Sue's been juggling the ball on many items recently, and sometimes I feel her work goes unappreciated. I know as a board, we certainly don't agree on everything, and the same is true with some things brought forward by our town planner. But disagreement does not have to breed disrespect, especially if you're just doing your job. I respect the support we get from Sue, and I expect it to continue. I certainly welcome the ideas to explore new options being brought forth by Sue, and she's just doing her job by doing so. As a board going forward, we need to support on supportive ideas and build consensus. I would welcome constructive ideas instead of destructive ones moving forward. In the end, it's the voters who decide on our recommendations. At this point, I'll allow any public comment on items that are not on agenda with a limited time limit. Is there anybody from the public who wishes to speak? Okay, first item on the agenda is A&R 208. I have a comment before we get into the A&Rs. Our mission is to administer the zoning bylaws and all the subdivision regulations, which include A&Rs that come before us. We need to protect the town from appeals, but also be fair to applicants. I will ask all board members to do some homework and become familiar with the laws that we administer and share our knowledge with one another. To that end, I've asked Gary Gilbert, who has unique expertise from his time on the ZBA and past planning board, to pre-vet A&Rs as they come in. After each A&R presentation tonight, I will ask Gary to speak to the board on what he's determined from his review. To develop informed and experienced researched opinions about laws we are administrating, board members should become familiar with the laws we administer. To that end, I plan on asking the town if we could have an education center session on A&Rs with town council or an appropriate expert at a future meeting, most likely after a special town meeting in June. With that said, I will open A&R 208 Summer Street, and I assume, Mr. Glovsky, you are going to present or speak?
Yes, that's a correct presumption.
Okay.
Good evening. I'm Mark Glovsky. I represent the Caris Summer Street Nominee Trust. I'm here tonight with Deborah Colbert, who I don't see on my screen, but she is the engineer from Hancock Associates who's been working with the family and with me on this presentation tonight. The property that is the subject of the A&R application is on the northerly side of Summer Street in zoning district C. It's a piece of property that contains 8.5 acres, and we're proposing dividing it into 2 lots. We can either show I can, if we share the screen, I could show the plan, or we can just talk about it because I think you all have the plan in your package, whatever you'd prefer. But
Yeah, Mark, did you want to be co-host or Deb or? who?
sure, let's see if I can do that. There we go. Do you see the plan?
Yes, we do.
Okay. What you've got is the depiction of the division of the property into 2 pieces, lot 1 and lot 2. Lot 1 is the property on the easterly side. It's the smaller of the 2 lots. It contains 2.2317 acres, and it has 150 feet of frontage on the northerly side of Summer Street. Lot 2 contains 6.17 acres, more or less, with about 584 feet of frontage on Summer Street. With the application, we submitted a short memo, which essentially runs through the criteria for determining whether a plan should be approved or not. And essentially, as you may see in the memo that you all received, I trust, there are 5 questions that need to be asked. The first question is whether each of the lots fronts on a public way. And I think in this case, it's obvious that both lots front on Summer Street, which is not only a public way, but it's a state highway. The second question is whether the lots meet the minimum frontage requirements. And the minimum frontage requirement in District C is 150 feet. which both lots satisfy. The third question is whether each lot can obtain access from its frontage. And the answer to that question is yes, there are no impediments to access from the frontage. The fourth question would be whether the way that the lots front on provides adequate access. And in this case, as I stated in the memo, a Summer Street is safe and constructed and wide, and certainly does. And lastly, does each lot have practical access from the way, Summer Street, to the buildable portion of the lot? And the answer to that question is yes also. In this case, just as a tool, we provided an additional plan that is the proposed common driveway plan that depicts, I'm going to put that plan on the screen if I can navigate correctly. Oops. It's this plan, which I trust you can now see, that shows the common driveway in yellow. And off the common driveway, about 100 feet from Summer Street, it shows the connection of a light orange colored driveway coming from lot 2. There is not a plan to construct that second driveway. There's good reason not to have 2 driveways. But what this plan is being submitted for is illustrative purposes to show that, in fact, we could, without impediment, connect the buildable portion of the lot to Summer Street, in this case, via the common driveway. I think that I also in your package is a letter from Deborah Colbert, which confirms that the common driveway could be constructed to satisfy all of the legal requirements, the dimensional requirements that are set forth in the Manchester zoning bylaw. And she ends her letter to you by saying, the shared driveway will obviate the need for a second curb cut, will provide safer vehicular access and egress, and will minimize the environmental impact of a second driveway. It seems like a very straightforward approval not required plan. I should point out that on this common driveway plan, there's a box that has the zoning requirements. And unfortunately, there are a couple typos in that box with respect to frontage and lot width. The numbers are wrong, but this is only by way of an example. And it's not part of the A&R plan, so I don't think it's critical at this point. And I would be happy to answer any questions that you might have. And Deborah's with us too, if they require a little more engineering background.
Okay, thank you, Mark. Any questions from the board? No questions
Just
from
one
the board?
question. Just one question, Ron.
Yes, Mary.
The common driveway is not currently in existence, correct?
That's correct.
Thank you.
Any other questions from the board? Mr. Gilbert, any comments on your vetting?
Yeah. I think it wouldn't be good for anybody to have 2 curb cuts side by side there. Initially, up until recently, we didn't receive some succinct answers from Attorney Bobrowski about A&Rs, but since his letter came through to us, he made it clear, as well as our bylaw section 5.1, which actually anticipates exactly this kind of situation where the frontage, which they have 159 feet, I think, or
150 on one.
yeah, has impractical vehicular access, and therefore, it explicitly says, therefore, a common driveway can be used. I think the only issue that I would recommend to the board here is that either we endorse the A&R plan with a condition that the common driveway be filed with the registry at the same time. If you can apply conditions to A&Rs, which is still a little bit of a squishy point legally in my head. I think you can condition A&R plans. But I'd like to see a drawing that is recorded at the registry that shows I see a green color, just a single common driveway, not both, because the plan submitted is confusing. So it should be a singular common driveway. And I assume this is all owned by one property owner right now, or?
Yes,
Okay, then, right, then that property owner would have to file, if I understand things correctly, this common driveway plan with the registry. Is that correct, Mr. Glovsky?
well, yes, but I disagree with you about the procedure. I think that, as you know, the A&R endorsement doesn't say anything about buildability. And that's critical here, because you're just saying, yes, you can divide the property. Subsequently, Paul Orlando is going to have to make a determination as to whether or not he can issue a building permit. At that point, he will need evidence of the fact that the common driveway will satisfy the requirements of the planning board. And in doing that, as you pointed out, section 5.1 point whatever, he's obliged to get an opinion from the planning board. So the way I see this happening is the approval not required plan can get stamped and it can get recorded, and the property could be conveyed, but it couldn't necessarily be built on until Paul Orlando makes that determination. So I think it's a relatively simple process, and I don't think we need to put the cart before the horse. I think that at this point, the plan that was an exhibit merely to show that a common driveway could be constructed satisfying the dimensional limitations imposed by the bylaw, that's just a tool. And ultimately, when building plans are ready to be submitted to Paul, he's going to then need to make a determination as to whether or not he issues the building permit. And I would suggest at that point, he would come back to you and get an opinion with respect to the common driveway.
That makes a lot of sense, Mark. I went there today, and the curb cut is 17 feet wide and all that's required is 16 feet. And the land is quite clearly could easily be modified to allow for the common driveway. I'd like to see them, and I think in the past, the planning board has asked to have them both filed simultaneously, but you're saying that's not needed. So I guess I would yield to your expertise. It certainly is a bigger hurdle and a separate hurdle to get the building permit. It's much more involved than getting the A&R endorsed. So those would be my comments for now. I think Sarah has something to say.
Sarah, go ahead.
Yeah, I agree with Gary that I think this deserves our endorsement. I think previously we had talked about the issue of wetlands along the frontage, but I think the A&R handbook is quite clear. And I'm going to read from it. I know Mr. Glovsky gave us some case law, but in the A&R handbook, they say the appeals in a Corcoran versus Planning Board of Sudbury, the appeals court ruled that the planning board could consider the presence of wetlands, etc. The Mass Supreme Court granted further appellate review and reversed the decision of the appeals court, which means that we cannot consider the existence of wetlands. I think if it's a body of water, that's a different matter. It doesn't appear that that's the case. So I would concur that this is an A&R endorsement, ready to go.
Thank you. Christina, Mr. Delicio.
So I just want to confirm, this is not the first time that this has been in front of us, correct?
Are you asking me?
I'm asking the applicant, or you can answer.
I don't know. Deborah?
We've come before you, yes, for this property to subdivide for 3 lots. And your recommendation was to come back and only prove that we could actually get a driveway in without going through the wetlands. And so that's what we did.
Okay, I just wanted that to be part of the history. I think we've set this back, so as part of this history in our minutes, I want to make sure that we record that and that history. That's it.
Sadly, I wasn't part of the first plan.
I don't think the first plan was an A&R application. I think it was simply advisory.
Oh,
I-
I think it was actually denied a few years ago.
I
Maybe.
wasn't part of that years ago. I'm just recently been working with this client, so.
Okay, so we didn't look up the history as a board? As part of the
Ron,
review process?
Ron, the history of their upcoming before the town isn't relevant at all to us endorsing this plan. I think at this point, I'd like to make a motion that we endorse the A&R plan. I don't know the number that would be assigned to it. Could you help me make that motion, Ron?
Yeah, Sharon, do you have the number for this? And
Ron, I would like to know that I was just interrupted and overspoken. So as a point of order, I think that was inappropriate.
okay, listen, I'm going to enforce that you go through, ask the chair to be recognized going forward. I'm asking Sharon, George, if you're on, do you have an A&R number for this?
Sharon's not doing the minutes. This is Gail Hunter, and I am doing the minutes tonight.
I'm sorry, Gail,
And
is there an
moving
A&R?
forward, not one that I have at hand, but I will add it to the minutes.
Okay, Gary, if you want to make your motion and say an
Be the next,
A&R number to be determined,
the next sequential number from the last one. I think we've done that before.
okay, I think that will stand. If you want to make a motion,
Yes, and that's based on a plan of land submitted by Hancock Associates. I'm trying to read what I have on my screen. I don't have the date. I can't read it. Dated.
You want the
Mark,
date?
maybe if you,
March 30th.
Mark, if you could put the title block up on screen again, maybe
Sure.
blow that up.
Yep.
Dated March 9th, I see on here. It's the sheet, there's only one sheet of the plan of land in Manchester by the Sea, Massachusetts for Karis Summer Street nominee trust, care of Lisa Frakowitz.
Correct.
There you go. Can you see that?
No,
No, but I think I read the title block, I believe.
Oh, okay.
okay,
And we're not, I forgot we're not sharing anymore.
so Sarah, do you have a question or is your hand
Yes,
up?
I was gonna second it. We need the scale, which is 1 inch equals 40 feet. And the date of the plan is March
9.
2022.
Yeah.
And the address is at 208 Summer Street. So I second the motion.
Okay, so a motion's been made and seconded. Is there any further discussion? Mary Foley.
Thank you. And perhaps Mark Glovsky could answer. I've been reading that for common driveways, the common driveway needs to be in existence before an A&R approval. Could you speak to that?
I don't think that's the case. As I said a moment ago, I think that the building inspector will need to confirm that adequate access is available by a common driveway that satisfies the planning board bylaw before the building permit issues. And he's obliged to get an opinion from the planning board before he does that.
Thank you.
Ron, could I make a piggyback
Thank
question
you.
on
Is there
that?
any further?
Ron,
Yes, Gary, go ahead.
since Mary asked it, it sets the stage for the piggyback question. But the planning board does have to make a determination, Mark, that there is feasible or practical access. If it's obvious, it would not be in any way approved by the building inspector, we could then not endorse the A&R, correct?
Yes.
Any further discussion on the motion?
My hand is up, Ron.
Yes, I was asking for board. Yes, go ahead.
Oh, sorry. Deb Colbert here from Hancock Associates. Just to be clear, I have had numerous conversations with Paul and he has approved this plan verbally to me. And we will have to come back and get an opinion from the board in regards to the common drive, but he's fully aware of it and he has seen it.
Thank you, Deb. Any further discussion from the board? Having seen none, I'll take a roll call vote on the motion. Ms. Creighton,
Yes.
Ms. Delicio,
Yes,
Ms. Foley,
Yes,
Mr. Gilbert,
Yes.
Mr. Olney,
yes,
Penny,
Yes,
the chair votes yes. Okay. Thank you.
Thank you very much.
Thank you, everyone. Have a good night.
Okay, I have 6:59. Almost timed it perfectly, but I would like to open the public hearing, but I'll wait till 7 o'clock, which is seconds away to be official, especially since I see Mr. Wilson online. Want to do anything that might upset him?
Ron, I have a question. This is Christine. I don't know if you can see my hand.
Go ahead,
So I
sorry.
guess going forward, I mean, is there a reason why we don't have previous applications in front of us with this application, the history? These are relevant, why we denied it in the past and why it came before and it wasn't passed. So I do think this information is relevant. I think we have several staff members at our disposal, so I'm not sure why we're not getting these packets in that kind of a manner. And additionally, I would like to express my concern about using Mark Bobrowski. We hired Mark Bobrowski for recodification, not A&Rs, and I would like to know, for the record, why we're not using town council. And I don't approve of the memos that are coming back and forth. There's nothing on the email that came back that even has Mark Bobrowski's name on it. It's not discernible who said what. So this is very concerning me, and I would like to get that out there. Going forward, I think we should use town council. That's what they're there for. Thank you.
Okay, thank you. Okay. Regarding the history, I think it's kind of what's before us. They've changed the plan. I don't know what having the history would be, relevancy it would be, but we can certainly make note that it has been previously presented as to that comment.
History is very
Okay,
important. Learn from it. Bottom line.
Okay, at this time, I'd like to open the continued public hearing on the special permit application for a site plan approval for Cornerstone Church. Public hearing notice has been duly noticed and advertised in the Cricket as follows. In accordance with Mass General Laws, Chapter 48, Section 11, the Manchester by the Sea Planning Board will hold a public hearing on September 27, 2021 at 7 p.m. virtually via Zoom to consider the application of Cornerstone Church for a site plan approval with special permit under section 7.5 and 6.9 of the zoning bylaw as greater than 10 parking stalls are proposed at 189, 191, and 193 School Street, Assessors Map 38, lots 25, 15, and zoning district A. Since last meeting, a draft decision was posted by Laura Tenney and board members were asked to comment. After my initial comments to Laura were incorporated, it's my understanding that Gary Gilbert made some additional comments to simplify the site walk description, and Sue Brown made some minor edits. Both, Laura, correct me if I'm wrong, were incorporated into the documents.
That's correct, Ron.
Okay, if there are no further comments, I would ask to close the public hearing and vote the decision. So at first, I would like to open the public hearing, the continued public hearing. So can I get a motion to open the continued public hearing? The continued public hearing was from when was that? From March 14th.
Moved.
Seconded,
Seconded.
Ms. Creighton,
Yes.
Ms. Delicio. Christine, you're on mute.
Yes.
Ms. Foley,
Yes.
Mr. Gilbert,
Yes.
Mr. Olney,
yes,
Ms. Tenney,
Yes.
chair votes yes. So the public meeting is now open. And I would take any comments on the draft decision or any comments from the applicant. Otherwise, I would close the public hearing and vote the decision. Ms. Mary Foley.
Thank you. Thanks, Laura, for doing this. This is a really good job. My only comments are administrative. One, I believe, I call her Christine, but I think Christine goes by Christina legally. So I think that needs to be her signature. And I don't see a place for a date. I mean, we have specifics in here, 20 days from the date of filing, things like that. There's just April 2022. I was just hoping there'd be a more specific date.
A date on the decision or a date on?
I guess whatever is common practice on these approvals. What is it? Is it a date when it's signed? Is it a date when this hearing is closed? I was just looking for a specific date instead of just the whole month of April.
Ron, may I
Let's make it-
respond?
Yes,
I'm
Ms.
able.
Tenney.
Thanks,
Yes.
Mary, for those comments. So I'll certainly correct Christina's name to her legal name. And for the date of decision, what it says in there now is that it says date TBD for the close of the hearing, which may be today. But if that's not enough and we need to do an additional, date of the letter, happy to put that on in too. And perhaps Sue Brown can guide me as far as the template. And it also needs to go on letterhead, as I think Gary or Sue already commented on it. So that will be done as well. Thanks, Mary.
Okay, so the only comment I have in addition is asking the applicant to provide a performance bond under section 6.9.7. Any comments on that?
you'll have to help me understand what the amount of the bond and the form of the bond.
Well, the bond would be for the construction to make sure that the town has money if you abandon the construction, that we have money to complete or finish up.
Well, Mr. Chair, this is the first opportunity we've had to talk about this. I'm sure you wouldn't want a bond sufficient to cover the construction of a church on private property, are you concerned about a bond to complete work crossing any public property? Is that the purpose of the bond?
Yes.
Okay, thank you. We'll look into that, and we're happy to provide a bond sufficient to finish any work within the public way in the event circumstances happen as you described.
Thank you. Ms. Creighton?
I do think that modest bonding is appropriate. I think the other piece of this, which is not subject to our special permit, but is that pump station. So I think that's probably our biggest vulnerability, is that if there was some sort of disruption to the sewer access that goes through the property. So that would be my biggest concern about what our sort of the town's liability is here, because that would be I think that the work within the public way is quite small.
Yeah.
It's the sidewalk on School Street and perhaps a curb cut at Mill Street, but presumably, you know, we're going to get a lot of betterment along there. I'm not proposing a solution. I generally do think that having some bond is a good practice. Maybe a modest amount of, you know, $20,000 or something that, so maybe Sue can advise us too.
Mr. Gilbert?
20,000 maybe, well, it would be for sidewalk disruption and rebuilding, right? And it would be for
Right.
potentially a curb or something on Mill Street. And I'm not sure about the sewage issue, but is this something that the building inspector would determine the amount of the bond prior to issuing the permit? And we can just, we need to add do we need to add language to our decision requesting a bond for anything that touches the public realm, public rights of way? And I don't really know the process to determine the amount of the bond, but it definitely could be some thousands of dollars for sure.
Sue, I'm sorry, Mary Foley.
Thanks, Ron. I would suggest, since 6.9.7 does say it's per the planning board, that we have some formula that we're using. What has happened in the past? Is there a form, a spreadsheet that we can give an accurate amount rather than just kind of guessing at items?
I don't know if that exists. I know one time we had to try to calculate the construction cost ourselves, but
The DPW knows the dollar amounts, but does the building inspector normally speak with him and come up with a bond amount? I don't really know.
So Ron, I'm saying that the bylaw says the planning board should do this. So I mean, obviously we can do it in conjunction with other people, but if it's supposed to be coming from the planning board.
I hear you. Mr. Drake?
Yes, if I may just suggest that before we commence the sewer work, that we submit a cost estimate of the cost of the sewer work within the public way and bond for that amount. The majority of the work on that sewer is private, on private property, and there is a recorded sewer easement agreement that affects the church property plus the three abutters, the three residential abutters at number 2, number 4, and number 6 Mill Street. And that recorded sewer agreement does say that the 4 property owners collectively are responsible for the repair, maintenance, and replacement of the whole system. But notwithstanding that, our plan does propose putting a manhole within the public way. And therefore, we're going to need a permit to open the street. And I'm just suggesting that we would have better information leading up to applying for that permit to open the street. And perhaps at that time, we could post an appropriate bond.
Okay, maybe we could leave it open-ended and be subject to an estimate from your contractor.
Yes.
And then our decision could state that you would provide a surety bond for that aspect of the construction.
Yes.
Okay. I'm thinking we can somehow get that language in, Maura, into our decision.
Yes, do we want to state that language here, Ron, or do you want me to?
Yes, let's come up with some language. The applicant will provide a security bond equal to a sum of work in the public way as to be determined at the time of construction, something like that, to that effect. Does someone have better language?
To be determined in advance of the time of construction.
How about permitting?
Or permitting.
of permitting.
Works. Is that Christine?
Permitting would be a better, yeah, that would be better. Any objections from the board on that language? Or any other comments? Not hearing any further comments, I'd like to make a motion to
Ron, I
close the
think,
public.
I think Sarah, I'm sorry to interrupt. I think Sarah
Oh,
has her hand up. Has had it
Sorry,
up a while.
It's hard. No, well, I had it up and took it down, sorry. So I think we should also in that language authorize release of the bond as work is release of the bond by the building inspector under in consultation with the building inspector and DPW director as work is completed. Because it can sometimes be quite burdensome for a construction project if the bond is held after work is completed. So I think if we ask the building inspector and the DPW director to authorize release of the bond as work is completed and work is completed satisfactorily, then it helps the applicant with its cash flow.
I mean, maybe we should know about that ahead of time.
so Laura, you have your hand up.
Yes, typically you'd say substantial completion.
Yes.
So
Of
we
the
could-
of the public
of
work.
the project. Yeah.
Absolutely.
I think of that portion of the work,
Yeah, okay.
the whole project.
So that wouldn't be substantial completion, but it would be upon inspection by the
Inspection of,
requisite inspector.
and Ron, if you mind, if I may,
Fine.
just to Christine's question, when I was on the planning board in Newbury, we had large performance bonds that were released by DPW director, building inspectors. We had a planning board consultant that inspected the work for us. It was an engineer. And so in this case, we don't have an engineer. This is not a huge amount of work in this area. So I think we can rely on the building inspector and the DPW director to inform us, but to be able to determine whether the bond should be released.
Christina.
I mean, so I completely agree. Oh, I completely agree. I guess it's just our responsibility. So I just want to be kept in the loop. So maybe if he tells us and we actually release it at the next meeting, I don't think that's too burdensome. It is the board's responsibility. And I completely agree with you on that point of the building inspector releasing it. We need to close the loop.
So you're talking about at the end of the, when the construction's substantially complete, you want the planning board to know? Is that what you're just saying?
Whenever we're going to release the money, I think we should be notified. That's it.
Can add that language in. Upon substantial completion, the planning board would be notified of the release of the bond, something like that.
That's fine.
Yes, I can say notified by release of the bond with the approval coming from DPW director and building inspector. So they're the ones who are authorized to make the release.
Excellent. Thank you. Mr. Gilbert.
Did you make a motion on this?
No, we didn't make a motion yet. We're talking about amending the decision. And then I would like to close the public hearing once we get these comments kind of sorted out, ironed out, and then vote the decision at the close of the public hearing, after the close of the public hearing.
Okay.
You've already voted to close the public hearing.
We did not.
Yes, you did. You moved and seconded it and took a vote. Oh, I'm sorry.
We voted to open the public hearing.
You're
To
right.
continue
I'm
the
sorry.
public
I can't read my little handwriting.
So Ron, I was just raising my hand because I just wanted you or Laura to try to restate what language we're going to add to the decision, so it's clear.
Yes, I plan to do that after I close the public hearing so we can vote on the decision as amended. We can do it now. But I still see some hands up. Mary Foley.
Thank you. Surf Village was before my time, so I wasn't part of the process for this, but I was on the board when we had to vote to release performance bonds, so I'm wondering how this is different.
It shouldn't be different. Ms. Brown, do you have a comment on the process, or Ms. Hunter?
I don't really have a comment on the process. I think it's how it was set up in the decision.
So we can vote to release the bond upon, I guess we'll hear from the building inspector and the DPW that the work has been done to their satisfaction. It'll come back to the planning board for release and vote. How's that?
Ron?
Laura?
Yeah, thank you. That was before my time as well, but I just question why the planning board would be releasing a bond. This is in the purview of the building inspector and the DPW. And it makes sense for them to report, but we are not the governing authority here in terms of the completion of the work. And I think we would be advised to not comment on when the work is complete. That's in the purview of the building inspector.
Okay. Ms. Foley?
Sorry for the back and forth. I just wanted to clarify what I was saying to Laura, that at least I'm going by our bylaws. So it puts the planning board in that position. I think we are consulted by the building inspector and DPW and all of that, but it puts us as the body to release the bond. Just going by the bylaw.
I don't see it as a heavy lift for the board. If it's back to the board, I don't think it would be a heavy lift for us to release the bond. So I don't have an issue with it being written into the decision. But I'll hear from more members. Ms. Delicio.
My video is breaking up. That's exactly what I was just going to say. It's in the bylaws that it's under our purview. So I agree. It's not our responsibility to inspect and say that it's done, but I think it is our responsibility to say that it is released. That's just, I think we need
Thank
to
you.
move forward.
Ms. Creighton.
Yeah, I was going to suggest the language, the applicant will provide a surety bond equal to the sum of the work in the public way at the time of permitting. Upon substantial completion, the planning board will authorize release of the bond upon advice of the building inspector and DPW director.
Perfect. I think yeah, I think you nailed it. Any further discussion from the board on this? Okay, I will take a motion to close the public hearing.
So moved.
Is it seconded?
Seconded.
Ms. Creighton,
Yes.
Ms. Delicio,
Yes,
Ms. Foley,
Yes,
Mr. Gilbert,
Yes.
Mr. Olney,
yes,
and Ms. Tenney.
Yes.
The chair votes yes. Okay, so the public meeting portion is closed, and I would like, since we're not meeting again for a month, I'd like to vote the decision as amended with the language as read by Sarah Creighton.
So moved, with our thanks to Laura and others for their great work.
I'll second.
Okay, motion's been made and seconded to approve the decision as amended. Ms. Creighton, any further discussion? I'm sorry. Ms. Creighton,
Yes.
Ms. Delicio,
yes,
Ms. Foley,
yes,
Mr. Gilbert,
Yes.
Mr. Olney,
Yes,
Ms. Tenney.
Yes.
Chair votes yes, it's unanimous 7-0. Thank you. Good luck on your church, Alden.
Thank you, Mr. Chair. May I just thank you and all the members of the planning board. The church and the members of the building team and I are very, very pleased with the outcome of this site plan review process. So we just want to thank you all for your very thoughtful and conscientious work. So I wish you all the best. Have a great summer. Thanks for your help.
Good luck.
Thank you.
Thank you. Okay, the next item on the agenda is A&R for 1 Spy Rock Hill. And I don't know who will be presenting. I have Kinder.
Yeah, my name's Tim McDonald. I'll be presenting along with our lawyer, Mark Glovsky, who's been advising us along the way, and he'll be able to answer questions afterwards. I'll share my screen if that's okay.
Yep.
You see that?
Yes, you've got several up. There you go.
Okay. What's before you is the survey to divide 1 lot at Spy Rock Hill into 2. What's unique about 1 Spy Rock Hill is that it is actually fronting on 2 streets. It's the only property on Spy Rock Hill that does so. And as such, it has on C Street frontage of just about 270 feet. And the division into 2 lots would allow for this first lot, lot 8A, at 0.6 acres or 26,124 square feet, along with that frontage, as well as the lot 8B, which is the existing home with 154 roughly feet of frontage on Spy Rock Hill to be approved. Now, of course, as Mark mentioned in the last A&R application, there are other requirements having to do with the whether the access to that frontage is viable. And we similarly did a civil engineering drawing that provides a design for a preliminary design for a driveway along that fronts C Street. And even though we didn't have to, I just wanted to be sure. So we met with Charles Dam, the Director of Public Works, as well as Sue Brown, the town planner, and Paul Orlando, showed them the survey drawing as well as the civil engineering drawing, and they say they said they saw no issues with respect to approval for the project. The next day, we actually met in person at the site with Charles and his assistant, who reviewed not just the drawing, but he wanted to see the site itself and make sure he fully understood the design. And afterwards, again, he saw no issues with the project being approved. Of course, this is just the beginning. There's stormwater management, runoff calculations, and lots of other things to design for the building permit. But with respect to the A&R application, they saw no issues. One of the reasons why he came out was to just come to terms with all of the questions of how this driveway would meet with C Street. And it's 50 feet from the corner of C Street to the current driveway as designed. Now, I know that there are no minimum or maximum widths or limits to entrances or distances yet in the bylaws, but I understand, if I'm correct, that you're proposing some of these, some of this data, including 20-foot distance from a corner to a driveway. We've obviously with 50 feet, that should be no problem, as well as all the other issues around site and so forth. And then just to give a much clearer understanding, because this is a fairly unique site, of just exactly what does this driveway look like? What is the slope? It's 127 feet of travel distance going from C Street to the kind of level section of the driveway. But it's only a 12-foot rise, which allows for a 9% slope driveway. And I just thought it might be important to visually understand why that is, because really where the driveway flattens out is about right here. But because C Street drops so significantly, the height of that elevation of the ledge is exactly the same height as the elevation on top of the existing retaining wall further down the property line. And so because of that, the height, the 12 feet of lift for the driveway is not that significant. And it's just very difficult to read that in a survey drawing. So I just thought I might demonstrate it here. I thought it might also be helpful to see that all the utilities are very close by. And we would expect to bring those utilities under the new driveway up to the garage basement area of the proposed house. This section tells you how we would do that. And it also tells you that this driveway proposal is mostly fill. There's no intention to blast any of the ledge. We don't think there's any need to. We will be continuing this retaining wall that's existing all the way along the property line and filling that area, which will allow us to run our sewer, water, electric, gas, and so forth. We even did a cut and fill calculation to demonstrate that 99% of this driveway is really about fill. So just in terms of the impact on the neighbors, there will be there's no intention to do any blasting for this. The site currently is primarily ledge, and a lot of the runoff comes directly onto C Street, and our neighbor across the street, Steve, has already has told us several times, and we've witnessed it, that when there are real downpours, it really just inundates the street in his basement. And so what we're hoping is that not only are we going to do what's required in terms of keeping stormwater on the property, we're going to actually better the situation in pretty much three ways. One is the roof is going to have a green roof, which is a stormwater management technique, so that impervious building will actually be pervious. There are also detention areas and detention basins, spreaders, 1,000-gallon cisterns that we're going to collect and reuse the water on site. And now I know this is not required because it's zoning, and this will come about later with building permit zoning application, but we just wanted to let you know. And the house is not fully designed yet, but we just wanted to let you know we're working within all, meeting all zoning requirements for the property. This is the existing condition of that corner where it roughly almost meets with Summer Street. And as you can see, this existing retaining wall, which is on the property line, is really what we're using as an example for how to design this project, how to design this driveway. And this is just a really quick image that is actually inspired by a couple of blocks away on 3 Masconomo Street, a very, very similar slope, length of driveway, and retaining wall for C Street that we plan on using. So that's all I have in terms of a presentation, but I'd be happy to answer any questions. And again, our attorney, Mark Glovsky, as well.
Okay, thank you, Mr. McDonald. Very nice. Any questions from the board? I see Mr. Gilbert with his hand up first.
What I'd like to know the height. I've looked at the proposed driveway plans. What's the maximum height of the retaining wall? Is it around 10 feet?
Roughly, yeah. It really varies based on the ledge condition. I think that 3-dimensional drawing gave a best sense, but yeah, roughly 10 feet.
Miss Creighton.
The proposed driveway that you show is entirely in the front setback, am I correct?
Sorry, I dropped, you dropped off there.
It looks to me like the proposed driveway is almost entirely within the front setback. Is that correct?
Correct.
And your the other thing is that your image shows cut and fill of 300 cubic yards thereabouts,
Correct.
and no ledge removal, or yeah, when that last image you showed looked to me like you'd have to take out some ledge there in order to
Yeah.
that big rock there.
Yeah, so the intention is no blasting. I didn't say that we weren't going to be removing any ledge. There's a very small portion we think will be required, but of course there's, even the topography. I had the surveyor come back and analyze the topography much more carefully along C Street, but even with that, it's a bit of an approximation. So if any ledge is to be removed, and I've already spoken with an excavator about this, they have no problem removing it with a excavator and a jackhammer.
I have 2 other questions, Ron, if you don't mind.
Yeah.
One is who owns this property?
It's under the estate of Elizabeth Kinder, and the owners are Elizabeth Kinder and Kurt Kinder.
Has it transferred?
No.
So the application lists Elizabeth Kinder as the applicant and says that she is the owner of the property, but I think that's not exactly accurate. Because I believe at least the records in town hall do not show any transfer of land since 1996. So that's just an administrative thing that probably should be cleaned up.
Sure.
And I'm suggesting, one other question is, do you actually plan to build this, or are you going to come in from the other side?
Yeah.
I mean, I'm not sure it's relevant to this discussion. But
Yeah, we see that this is the most appropriate access to the property for a couple of reasons. Number one, utility, the distance to the utilities is about half what it would be if we went the other direction. And we want the utilities to come into the basement, given that we want, for sewage, for instance, we want it to be draining through gravity rather than pumping. And we actually just think that the access makes more sense on C Street. It's about twice as long. We don't have to bring all of the cars up Spy Rock Hill and the existing driveway. So the intention is to build it.
Ms. Foley.
Thanks, Ron. Could you address a little more? I believe you said the slope of the driveway is 9%. I'm trying to understand the feasibility of that curb cut in that place and the safety of that. I think what we need to look at is also, is the access safe? That's a very bad corner. Obviously, because of the topography, you can't go further down C Street, which would make more sense safety-wise. So if you can, again, go over that slope, because looking at the topography online, I see elevations of 29 and then quickly 39 and then up. So I'm trying to figure out the 9% slope and the safety part.
Sure. I mean, I think the best, I'll just address the slope issue. The best way to understand the slope of the driveway compared to the slope of the land is to look at the civil drawing. And so it tells you every 2 feet going up the driveway, what distance you go within that 2 feet. And then you add that whole distance up and divide that height change by that distance, and that gets you the slope. It's important to look at that over top of the existing topography in the survey. So that's just numbers. It was drawn as the civil engineer saw fit. And as far as the safety is concerned, that's precisely why I wanted to talk with DPW in order to understand what defines safety. How would this not be safe? And he came out and he said there are no requirements about the distance from the driveway to a street, but his understanding was that that this was fine based on what he saw. Because the other thing about the connection to Summer is that C really opens up wide. And so there's actually a lot more visibility at that corner than, frankly, as Spy Rock Hill meets Summer Street. Where Spy Rock Hill meets Summer Street is one of the most dangerous intersections I've experienced, because you can't see people coming over the hill. Whereas Summer Street, it's significantly wider as it enters. I mean, C Street's significantly wider as it enters Summer. And so, Charles didn't see there would be any issue around safety.
Any other comments from the board or questions? Ms. Tenney.
I'm looking at the proposed driveway and reading through the A&R handbook about physical obstructions and practical access from away. And I'm having difficulty seeing how this access is practical, particularly where it is entirely within the setbacks for the property, and coming so close to the intersection of C Street. And I don't pretend to have the role of the DPW director, but just as a clarification in terms of the visibility of C Street, I think it's quite limited actually by the crest of the hill and the short sight lines coming from Summer Street. So far this is not passing the test for me in terms of reasonable and practicable access to the site, given the topographic impediments.
Thank you, Laura. Mr. Olney.
So I want to echo what Laura just said. I believe one of the tests for an A&R is that there is practical access, existing practical access to the site. And clearly there is not existing practical access, there's hypothetical access. And I think the other part of this that's a little troubling is that to put that driveway in and disturb that much of the frontage along the street requires a special permit. And we're certainly capable of issuing a special permit, but we haven't been asked to approve one. We don't have a plan for a special permit. So I think this might, I'm not sure what the sequence of events has to be to make this work, but I think to make it a practical access, there are a couple of preliminary steps that have to go through. And I guess I defer to Mr. Glovsky as to what those steps might be.
Well, if I might respond to
any
a few
comment?
of the points that have been
Yeah,
made. Are you asking me now, or are you still going to talk among yourselves first? I'm happy to hold off.
Well, Mark, I have two more hands up. Maybe we'll go through the comments from the board, then we'll go to you.
It's fine. That's fine.
Sarah Creighton.
Thank you. I do think that we should get town council advice on this. I think there are a couple of issues. The first is I think the applicant needs to withdraw the A&R and resubmit it with the correct owner identified. I don't think we can have a plan for somebody who's deceased. The second thing is that the plan, I agree with Laura and with Chris that the practical access is not existing. And I think that the proposed access does not exist. And we should get advice about this from town council. The access would require a curb cut into a four-way intersection with a blind corner. And a curb cut permit has not been requested or received by the planning board, which is currently the curb cut granting authority. And secondly, the proposed access would require the removal of ledge and I think he said 300 yards of fill within the front setback, which would require a special permit under section 6.12.2D, and no special permit has been applied for or much less granted. So I'll at some point I'm ready to make a motion, but perhaps want to have more discussion and hear further from others before we do that.
Okay, thank you, Sarah. Mr. Gilbert, you had your hand up.
Yeah. There's a number of things we said about this. I think we're falling into the trap of trying to render an opinion as to whether they deserve a building permit or not. And that's not what A&Rs are really about. They're about, do they have frontage or not? The letter we received from the abutters, the first three paragraphs keep talking about frontage, saying they don't have it, but we have a stamped drawing by Richard Loud, registered surveyor, that they have 270 feet of frontage. So they do have frontage. The A&R, in my opinion, should be endorsed. But I understand this happens all the time where the board tends to fall into the trap of should they get a building permit or not. That is, in fact, a big ledge to overcome, if I can use a bad term. It's a hill to climb, let's say. There are a lot of issues before they get the building permit. Our job here is not to design the building, and much of Tim's presentation was about the building design, and that's all fine and good, but that's between him, the building inspector, and the DPW in the end. It's not our job here to decide whether there's safe access. That intersection is scary a little bit because C Street's so wide. A lot of the streets we have downtown, what we've done to them is narrowed down the roadway to make it safer for pedestrians. It's a little bit crazy looking there because the roadway is so wide. It's not the fault of the property owner. And I don't believe it would be a reason to deny him a curb cut, but it certainly would not be a reason to not endorse the A&R plan. If in the end he doesn't get a curb cut, he can't build his house. If he doesn't get a building permit, he can't build his house. The slope is not an issue because we have no language about slopes for individual driveways in our town. And this slope certainly seems within the realm of normalcy. We don't have any regulations. Some towns say driveways can't be greater than 15% slope or such. We don't have that regulation for single driveways for single houses. The letter from the abutters addresses Poulos and the planning board of Braintree, which is a famous case. But I think it's worthwhile to point out that the fact that they denied that A&R did not mean that they were permanently forbidding it. They were just denying it at that point in time, because that person had a guardrail, had to negotiate with the state to remove it, had up to 30 feet of fill to add. It was a different situation. They even say in the decision, the planning board is authorized to withhold the A&R endorsement, but neither the slope nor the guardrail constitutes an insurmountable impediment, meaning that it was surmountable if the person just fixed the topography and changed things, which is true for many of the case laws in the A&R handbook. If the person, changed the facts on the ground and resubmitted, many of them would have gotten their A&Rs. I would go further and say, well, I mentioned slope. The letter from the abutters asserts that because they have a steep slope to deal with, they lose their rights. They have no right to develop the land. I think that is not a really fair thing to say. There's enough land there, as we have heard from before, for 3 houses. He's proposing to do 2, and people have rights if they own property. I would suggest that that we endorse the A&R and allow the building inspector to do his job and allow the permitting process to do its job, because there are a couple of permits mentioned here that do need to be obtained. But by endorsing the A&R does not mean this person can build their house. Not at all. It just means that they can subdivide the property. So we have, I think, 3 potential options that I'd like to hear Mark comment afterwards. To endorse it straight out. The other option, as Mark Bobrowski has suggested, to endorse it but hold the plan in escrow with town council to not be released until all permits have been obtained and he can proceed to build his house, or until the driveway is completed. And another option would be, just that it's endorsed with the condition written on the plan that the driveway needs to be constructed in its entirety before it could be recorded. Now, I'd really like to hear from Mark Bobrowski.
Okay, before we hear from Mark.
Sorry, Mark Bobrowski.
Before we hear from Mark, we'll listen to Christina has a hand up. Christina
Thank
Lucio.
Thank you, Mr. Chairman. So, well, Attorney Glovsky, I understand that you have lots of experience, and your job is to advocate for your client, and our job as a board is to do our due diligence. And I do have a problem with this board deferring to the applicant's attorney. We should be relying on our own town council. At this point, I think we should postpone any kind of decision and get town councils. We have an access issue, practicality issue, and the setback issue. So on those 2 things alone, I think we have some serious questions whether we should go forward with this. So Mark Bobrowski is not our attorney. He is for recodification. He's not our attorney for this. We did not hire him to look at A&Rs. We have town council for that reason, and we need to lean on those people at KP Law, not Attorney Glovsky. So I think that we should ask town council for their opinion and regroup. Thank you.
Thank you, Christina. With no other board questions hands up, Mr. Glovsky, did you want to comment on any of the
Sure.
board's concerns?
I hope you're not deferring to me. You shouldn't defer to me. I am here working with the applicant. I didn't file the application. I regret that it's not in the name of the owner, and I agree with Sarah that it should be refiled for that reason. And that would at the same time provide time for you to get an opinion from town council. I think that town council ought to agree with Mr. Gilbert that at this point, the function of the planning board is a little more limited than making a determination about safety of driveways and slope and that kind of thing. I think the real question is whether the construction of the driveway for access to the buildable portion of the lot is feasible. It doesn't have to, and in my view, that it doesn't need to be in existence at the time the plan is approved. I respect you for wanting to get an opinion from town council, and I think you should. And my guess is that Koppelman and Page is well-versed in this area of the law and should give you the right answer. And I think the right answer will be consistent with Mr. Gilbert's statement. And obviously, you're not going to vote on this tonight for multiple reasons. So I think that if I had a chance to consult with Tim privately, I would suggest that at this point, we'd be respectful of the planning board's desire to get an opinion from town council, and at the same time can resubmit the application. So what I would suggest is that it be withdrawn at this point without prejudice, and that it could then be submitted immediately, resubmitted immediately, and that would give you the opportunity to get your opinion from town council. Hopefully you
Thank you,
could
Mr.
get
Glusky.
hopefully you could get an opinion with respect to this plan, notwithstanding the fact that it will need resubmission.
Okay, thank you, Mr. Glusky. I think, Sarah, you had a motion just on that topic with town council, or is that what you were? have your
I
hand
do-
up for?
just respectfully asking, given that we have town meeting on April 25th, if you can resubmit so that we don't have the 21-day, we don't have to hold a special meeting for this in order to satisfy the 21 days from the application, to be having it constructively approved and us having to have a special meeting just to deal with this. So look at our meeting date in May, whatever that is.
May 9th. May
9th.
9th is our next meeting.
And count back, 15 days from that and then submit it if you don't mind. Otherwise, we'll have to have a special meeting.
And the only other thing I would ask if you would be whether you put the question to town council in writing and share the question with me, because in the past, there have been times when the planning board has requested opinions from Koppelman and Page, and they were done verbally, and the response was verbal, and we never really knew exactly what the question was, and that makes it challenging.
But Ron, I do have a motion. Oops.
Yes, so I think before you make your motion, the process will be that we craft it in writing, I agree, and we send it to Greg for push to go on to town council. I believe that's the policy now, so we don't have to go through any approvals. And so go ahead with your motion.
Change it because the planning board moved that the planning board that we request advice from town council concerning the following. And I can send this to whoever's Gail. The planning board expects receipt of an A&R plan with frontage along C Street. The existing conditions are ledge and steep slopes, and in the board's opinion, render the access unavailable. The applicant's application is expected to include a concept plan based on topo rather than survey, parentheses based on topo rather than survey, close parentheses rather than survey. sorry, I'm editing as I go here, to construct a driveway within the front setback. The plan shows considerable fill and possibly some ledge disturbance within the setback. The board requests advice concerning the denial of the endorsement and related advice. The denial of the A&R endorsement is for the following reasons. Practical access is not existing, parentheses, see Poulos versus Braintree, close parentheses. And 2, the proposed access does not exist and is therefore not adequate since, the proposed access would require a curb cut into a 4-way intersection with a blind corner, and a curb cut permit has not been requested or received by the planning board. And 2, the proposed access would require the removal of ledge and 300 plus yards of fill within the front setback, and appears to require a special permit under section 6.12.2D. No special permit has been granted. So I thought it would be useful to give the town council specific reasons for denying an A&R and see if those are relevant, and because I think it's important that we have a record of why we would be denying it. So I am presupposing a denial.
We did receive a plan with topo on it, an engineered plan, I believe.
I think topo,
We
not
received it.
the notes in it said that it was not based on survey. It was topo, like it was like a, but it wasn't based on a survey.
I thought the engineered plan had topo. Okay, I might be mistaken.
It had
It
topo
does.
lines, but not engineered, not surveyed.
No, it's surveyed with topo lines.
Oh, I thought there was a note. Okay, I'll take that
Yeah.
out. Thank you.
Okay, so that was a pretty long-winded motion. That was your motion, Sarah?
Share it if you want me to.
Would the board like to rehear the motion?
No, I'll just second it to get the discussion.
Okay, the motion's been made and seconded. Is there any discussion?
I would like to read all the verbiage she generated and maybe have a chance to comment on it before it's sent to town council, if that's possible.
Well, I think we should do it now, so
Okay.
so we're all together on this, and
Well, then
we're not changing.
The only point that, the biggest point that strikes me is that we have a stamped engineer's design plan for the driveway. And I think Sarah referred to it as, I don't remember her terminology, but when an engineer stamps a drawing, a plan, he stands behind the buildability of it. I think it can be referred to differently.
The plan is identified as a concept plan in the legend. That's why I use the word concept plan.
Excuse me, Ron.
Yes.
Today we received a stamped drawing that is very slightly different than what we had gotten 4 days ago from the engineer. I don't, maybe Sarah has not seen that.
Well, that came in late today. I did post it in our meeting packets, but I didn't expect the board to read it. It was at 3 o'clock today when I put it on, but these kind of last minute things, it's not really fair to the board to react. So, okay. So we have a motion.
Ron,
And
may I,
been
may
I
we
was
still
going to
discuss?
ask for comments. You go ahead, Laura.
Thank you. Sarah, I heard most of what you said, and I'm wondering if you use the language that says that access, that we're asking for advice on access when there exists a distinct physical impediment which would bar practical access. I think you used a sort of general term that was unavailable, but I'd like the council to tell us, actually, I'm looking at the A&R page 26, if there's a distinct physical impediment which would bar practical access. And elsewhere in the A&R document, they talk about topography as being one of those examples. Thank you.
Okay, so the board has a motion on the table and it's been seconded, so I will entertain board discussion on the motion.
I'm in favor.
Well, I have Laura and Mary with their hands up or
Awesome.
for discussion. Oh, Laura doesn't, Mary, you're on.
Just for clarification, I got a little lost in the motion. Is the motion also including that we're asking for a resubmittal? We're getting town council's opinion. And that's what we're voting on?
Well, the applicant has offered to withdraw. Go ahead.
Yeah, my proposal is that I was gonna say what you're gonna say. The applicant is suggesting to withdraw to get the ownership correct. Otherwise, I think we have to, you can't endorse a plan that doesn't have the right owner. So that would be kind of a showstopper, I think. So assuming that we'll get, so the motion I made is that we expect receipt of an A&R plan with frontage along C Street.
Expect a new one.
Well, we expect a plan that, yeah, for
Okay.
town council's perspective, that
Okay.
But we
Okay, I
expect
see two.
same documents, to be precise. They're not proposing changing the documents, so they should be rendering an opinion based on these documents.
So any further discussion for the board on the motion from Ms. Creighton? So I'll take a roll call vote on the motion to have town council opine on the A&R as described by Ms. Creighton.
Excuse me,
Ms.
Ron,
Creighton, yes.
sorry. Mr. Glovsky's got his hand raised. Maybe there's a relevant comment here before we vote.
Okay, I'll take comments from the public. Go ahead, Mark.
I was just going to suggest that perhaps you could send the plan, even though it doesn't designate the correct owner, to town council with the request for an opinion, so that the issues that Sarah identified are a little clearer for the council to interpret.
Yeah, I don't have a problem with that. I think that's a good idea. Let's get it to them and just say the owner and the name will change. I don't think that's relevant to their decision. I think we can do that. I see Tim McDonald and Scott. I mean, did you have any comments relative to this, Mr. McDonald?
Yeah, I was just curious as to how, there's a comment in the motion about there is not practical access. And I don't understand how that is being determined.
So my motion is, just to clarify, Ron, said,
Yes.
I think when we deny a plan, we need to have reasons. And so the proposed reasons that I suggest were curb cut and the requirement of the special permit, which is clearly about fill and ledge removal. So I was trying to give town council some specificity around things that they could react to. So and also just sort of for the board, my reason for wanting to go to town council, I think everybody agrees we should do that, is that it seems like, you know, someone is going to be unhappy here in either case. So we want to make sure that we have the support that we need, regardless of how this comes out. So.
Thank you. And Scott, could you identify yourself and who you are and your address?
Yes, my name is Scott Susko and I live on Spy Rock Hill, number 6 Spy Rock Hill Road. I just have a procedural question relating to the abutters, of which I'm one of. In terms of that question to town council and the town council's answer, how will we see that? Is that something the planning board will post? I'm just curious as to the answer and would rather see that before you all meet again, rather than at the next time you meet.
Yes, we can disseminate the information if it's deemed for public.
Yeah, that would be appreciated. Thank you very much.
Thanks. Okay, so we have a motion and it's been seconded, and if there's no further discussion, I'll take a roll call vote. Ms. Creighton,
Yes.
Ms. Delicio,
Yes.
Ms. Foley,
Yes.
Mr. Gilbert,
Yes.
Mr. Olney,
yes,
Ms. Tenney,
Yes.
and chair votes yes. So it's a unanimous 7-0 decision to send this A&R to town council for a further opinion as per Sarah's comments. Okay, thank you all.
Are you also going to vote on the request for leave to withdraw without prejudice?
Yes, we need to do that.
Thank you.
So the applicant has made a request to withdraw his application without prejudice.
So moved.
I'll
Is there a
second,
second?
I'll second it.
Roll call vote. Any discussion?
Looks like
Just
take
to
a
be
roll
ref-
call.
The minute should reflect her application, not his. Because it was Elizabeth Kinder is the applicant.
Sorry.
Ms. Brown, you have a comment on this before we take a roll?
Hi, Ron, I just, in fairness, I just wanted to let you know that there was another member of the public that had their hand up, and then you may not have seen it.
Oh,
There's Steve. I know it's difficult to see. And
I don't see anyone. Oh.
Steve,
Yep.
maybe on your next slide, next
Is this,
page.
I see, Steve, could you identify yourself?
Thank you.
Yes.
And is this,
Yes, hi, my name is Steve Colbert. I live at 9 C Street, directly across from the proposed subdivided lot. And I appreciate the board's work to approve a subdivision of a lot based upon street frontage. But a couple of things that were on Mr. McDonald's presentation that I'd like to be sure you saw. One, he referred to the slope of 9 degrees, but that was over a very long span. There may be much steeper parts of that driveway. I don't know what those are, but as Mr. Gilbert said, slopes not pertinent to the thing. The other standards that the board is trying to set are 20 feet from an intersection. Mr. McDonald said it's 50 feet, but it is also very close to the lot line, and you're trying to establish standards for 5 feet from a lot line. I don't know how close to the lot line it is, but that slope is really truly measured from the highest point on C Street so that that driveway can be less steep. So I'd like to point that out. Also, Tim, you noted the runoff, and yes, the runoff comes right straight to my house. Whether you build or not, I'm going to get runoff. But building your driveway so close to the street leaves no room for a cul-de-sac or any other way to manage the water down to the sewer drain. So it will continue to flow from the rock across C Street. And I think that's only going to get exaggerated by this plan. Thank you.
okay, thank you. On the motion to withdraw without prejudice, it's been made and seconded. Is there any discussion on the motion to withdraw? Otherwise, I'll take a roll call vote. Ms. Creighton,
Yes.
Ms. Delicio,
Yes.
Ms. Foley,
Yes.
Mr. Gilbert,
Yes.
Mr. Olney,
yes.
and Ms. Tenney.
Yes.
And the chair votes yes. It's a unanimous 7-0 decision. Okay, thank you all.
Thank you.
We'll be in touch. Okay, so it's 8:11. We are going to, the next item is we're trying to chop off as much of this bylaw, zoning bylaw changes as we can. We're not meeting again for another month, but possibly we may have to meet again. We'll see how far we get tonight on some of these. At this point, I'd like to turn the chairmanship over to our vice chair, Sarah Creighton, to run this next section of the agenda. Thank you.
Okay, thank you, Ron. Get myself organized here. It seems as maybe that we can do a couple things tonight fairly quickly, I'm hoping. It occurred to me tonight that our goal here is to decide to bring things to a public hearing. And so that is the what we have done, and we have been trying hard to get things pretty tidy for that. And I think we have accomplished that, with the exception of 3 topics. The first is section 6. The second is residential cluster, and the third is A&R, ADUs. But I think on residential clusters and ADUs, we may not all agree on the substance of them. And so I think the question is rather, should we bring them to town meeting, not to town meeting, to public hearing, and get input on the matters from the public? And we may not be able to firm up every issue, but should somehow craft them so that we can get input, and then following the public hearing, finalize what we want to put on the town meeting warrant. So I first wanted to just get maybe we'll take them one at a time as a strategy. Let's talk about that strategy with section 6, which Mary, you weren't here last, but just to refresh everybody's memory, last time we proposed essentially a complete reorganization of section 6 that Chris and Laura have been working on. And I think it's still got some details to be figured out, but I think it's going in the right direction, personally. And so I feel like that on section 6, a subgroup can continue to work on that and advance that to the public hearing. So let me stop there and ask if there are comments on that strategy for section 6.
Mary.
Oh, sorry, Mary, go ahead.
Yeah, when I looked at section 6 today, I was like, whoa, that changed. So I looked at the April 4th meeting minutes, and I wasn't clear by reading those, because there's a lot added to this that was not in any prior discussion. So I'm wondering, where that came from. There's a lot of it's somewhat drastic changes to me. It's saying something in the limited commercial district to go from 200 feet, a buffer of 128 to 50 feet. I don't know if that's even in our LCD bylaw change. There's a lot of new things on special permits that planning board can now waiver things. That is new. So I guess for myself personally, I don't feel comfortable that this has been vetted yet, but maybe I missed something at the last meeting.
No, you're right. We have not gone through it line by line. Chris and Laura took a stab at trying to get more toward performance standards rather than prescriptive standards. I think that was the general intent. Chris, why don't you explain?
Yeah, so just for everybody's benefit, section 6 is a hodgepodge right now with everything in the zoning bylaw that doesn't seem to fit is put in section 6. So now what we've done is it's now just special regulations. There are 3 sections to it. One is parking. We haven't really changed anything there. The second is signs, which we haven't done anything. We just put it into section 6 where it is now, actually. And the third is something we've been working on with Mark Bobrowski for the past 2 years. And there's not that much new language. What I really did was take all of Mark's recommendations for how to review special permits and put them into a single piece so that we can go through it as we review special permits and site plan, go through a site plan review process. We have all the standards right in front of us. And more importantly, perhaps a developer who wants to submit an application can look at all of our standards and see what he has to design to. So it's really for simplicity. At the last meeting I asked Mark whether this reorganization of his material made sense to him, and he had no problem with it. Then Laura took it and said, well, you know, there are standards for sustainability and for pedestrian and bicycle safety that we should add to this. And those sections are clearly shown in the new language. So to your point, Mary, this has all been discussed and vetted over the last 2 years with some recent changes which make sense and which Mark has looked at and seems to have no problem with. So that's why I think we should go forward with it. But, you know, we can go through each piece of it if you like and discuss its merits one way or the other.
Can I respond?
Go ahead. Yep.
I don't agree with you that nothing has changed in the parking. I could list easily 8 changes that I think are substantive or that are important. So I, you know, like it was taken out that it says the creating driveways that you don't have to back out of, that was totally taken out. Again, the LCD had a change to it. There's all sorts of new verbiage at the beginning, which basically talks about parking facilities more than actual driveways. So it seems much more commercial development slanted now than residential.
Well, actually, Mary, just to jump in here, that's not a change. That's the way the language has always been. The parking facilities design standards are for commercial, not residential use. Well, commercial and multifamily use, but not for single families. There are no parking regulations for single family houses in the current bylaw.
Well, there is for designing driveways that you don't back out. That's in our current parking regulations.
There is something in the curb cuts about it, yes, but not in the parking regulations.
So can I just come back to my my higher level question? I'm hearing Mary say that she would like additional review on section 6. Can we just go, instead of trying to do that now, can I hear whether we need, I'm trying to determine whether we need another meeting, and whether, two questions is whether we think we can get section 6 ready to go to town meeting as a block of text. And secondly, whether we need a detailed review. And I'm hearing, Mary, if I paraphrase your response, is that we need a detailed, a working session on section 6. Can you just speak to whether you think that moving it and consolidating it makes sense? That's, I think it seems to me that it's a good direction to go, but since you weren't here last meeting, do you want to just speak to that? Or
If I think it needs some review.
No, whether you think we should be moving, rewriting section 6 as part of our work for June, for a June town meeting. So
Yeah, I mean, I think, you know, it's all the parking requirements. It's, you know, number of vehicle, you know, number of off-street parking and
yeah, those are the details. So I guess the question is, you know, should we continue with this, pushing this one forward for June? That's what I'm trying to understand right now before we get in the weeds on it. Is there anybody who thinks that we should not try to rewrite section 6 and just abandon it? Because
Sarah, can I comment?
sure, go ahead, Gary.
I believe that I have witnessed time and time again with this, and it's partly because we're all worn down. It's partly because we spent almost 2 years to get this stuff developed and to discuss these points, and then town meetings kept getting delayed. This whole issue, for example, of whether we require people on every single property in town to have turnarounds on their property, we did discuss it, in my opinion, at least 3 other times. And we came to the conclusion that we didn't want to require that of every single property owner in town for single-family homes. A number of reasons were articulated. But the point is, I think what I would suggest to go forward, because this keeps happening, we say we never discussed it. Well, we did, and that forces us to rediscuss and remember what comments we made 2.25 years ago and 1.5 years ago. It's really tiresome. I suggest that we try to bring this forward to the public hearing, and then we make our final discussion amongst ourselves after the public hearing, and that's what goes to town meeting for a vote, because this will go on endlessly.
We do have to, we will have to make some sort of decisions about goes to public hearing in terms of scope, so we can properly notice it. So that is a challenge. So I'm hearing that we need another workshop on section 6. Laura, go ahead.
Yeah, I want to just respond to Mary, because I think she was just raising questions about things that might merit further discussion or just review. And this has been, we've talked about a lot of it. I think we're now kind of all crashing it together in one thing. So we're trying to make this one section that hangs together. And you know, even stormwater we've talked about, is it in or is it out? So I think there's something to be said for looking at the whole thing together, meaning together as a planning board and together as a single section. I'm wondering, Sarah, working backwards from the June town meeting. I mean, I know Chris and I have both been working on this a lot, and there is certainly a level of fatigue and feeling like, yeah, you know, maybe we're like 80% there. Do we keep sweating the details to try to make it perfect, or, you know, as close to perfect as we can get it? Or do we feel like it would be beneficial to try to get it in there now? And stormwater in or out is one big question for me. So can you help us work backwards from how much time we've got left?
Yes, we have to, if we're gonna have a public hearing in the middle of May, which maybe we could do it 1 week later, we need to have the public notice the week of April 25th, which is the week of town meeting. And so getting the public notice, we have to know what we're noticing. So we really are gonna have to have another working session either next week or the week of town meeting, you know, Tuesday or something of town meeting week, Tuesday or Wednesday, and then push the public hearing off 1 week. So we really have one more working session is the realistic, but I think we can do it if we people do their homework on the section 6. And I think Mary's, we can talk a little bit about that. Let me jump to 2 other issues. To stormwater, Mark Bobrowski did 2 things last meeting. He said that we should move stormwater to the general bylaw, and that we should not have the general bylaws have special permits. So our current stormwater regs have us as the special permit granting authority. So I was a little not sure what we do with that. I think I sent you an email about that, Chris. And you must not have known what to do either, because you didn't reply.
Actually, I think it probably is okay to put it in the general bylaw. With the planning board has other things that we do under the general bylaws also, like the blasting regulations. So, you know, it's not unprecedented.
Right. So the advantage of having it in the, in the general bylaws, it has greater applicability. But he did say you should not have special permit
Yeah.
in the general bylaws. So maybe it's a question for him. It's a simple question. Laura, go ahead.
Just, I thought we discussed with Mark that it's stormwater is typically in the zoning language rather than general, and that Sue, is she shaking her head? Did I get that wrong? Can you clarify for me? What did he say?
Yeah, he said, what he said was, is that if it's in the zoning bylaw, you can only regulate it when someone asks for a building permit.
Right.
Whereas if it's in the general bylaw, you can regulate it all the time. And he thought that was.
Right,
better.
somebody just, yeah.
So he did say that that stormwater is typically in a general bylaw, because it's not so much about use rather than a construction or something that you can regulate otherwise. So his recommendation all along has been to put it in the general bylaw so that it can look forward and back, as he described.
I think we can do that. Mary?
Thank you. This was already discussed, but I just want to make sure you have it in your timeline. If we're moving items to general bylaw, then the Board of Selectmen have to have a public hearing on the general bylaw.
I don't think so. No, they actually don't have to have a public hearing. I checked that.
Oh, did you check? Because last time we were saying that they did need to have it, especially if there was any changes whatsoever to the bylaw.
I think there is not a public hearing requirement for general bylaw changes.
Not a public hearing as in it doesn't need to be posted for the 2 weeks. They would have a hearing on it in their they would bring it up in their
Right.
open, in a meeting.
So the more things we can move to the general bylaws, the easier our job is.
We do have to notice to take them out of ours, so.
Yes.
So there's that.
Actually,
Okay.
it's too bad Alan Wilson's not here. We could ask him right now whether we can, in the same motion, take something out and put it into the general.
I already asked
bylaw.
them that. We
Oh, you
can't do
did?
that. Yeah,
Well,
sorry. Okay, so stormwater, I think we're gonna move that to the general bylaws, so we can do that. Accessory dwelling units were not prepared. I think to section 6 has, we kind of need to break the issues down to have a discussion in a working session, which I will do with maybe Chris and Laura, and then we'll just kind of get agreement on how we're going to move those forward. I'm hoping though, then the last thing, and then we will also take up the accessory dwelling unit in a working session. We'll have to decide when that's going to be. In that case, we're going to have to just decide what we're going to bring forward. The other one that has come up is floodplain, and I think we don't have a specific enough proposal for that unless there's something that can go into the general bylaws. I just haven't seen it. There were still some questions on it. So I know that there was a discussion about that. If there's something we can put in the general bylaws, then that's fine, but we haven't got a section on that, so. So the time remaining, it's actually only 8:30 tonight. I thought we were going to be a lot later, so I didn't.
Only, come on.
I know, so maybe we should take the rest of the night off. No, I was going to suggest that maybe we could try to make a decision about what we bring forward on the residential cluster. Because the provisions are actually quite similar. I mean, there are some changes between the proposed bylaw and the existing, but they're not wildly substantially different. Chris, do you think we can do that tonight? I'm happy to bring it up.
We can. I'd prefer starting with senior housing because I think that's easier. And then if we still.
No, we already voted to move that to public hearing. We voted that last
Oh, we
week.
did. Oh,
Yep,
I'm sorry.
that's
Okay,
done.
great. Yeah, then
Let's see if we can.
let's have it out and see where we can go. We can go with
Okay.
the residential cluster.
I'm gonna bring it up, and I'm gonna bring up the Word document, which is a little hard to see on the, I meant to put up a PDF of Chris's memo because he had the little graphics, so let me do that. Christina, go ahead.
All right, thanks. I guess I'm just looking forward. We've talked about visuals in each specific district for almost 2 years now. Like, I know Chris did that little drawing and I think that's great, but we were talking about what this looks like, worst case scenario in each district with the minimum lot size required. So I guess we've been talking about this not just since, a month ago, but years ago. So for us and the public to understand this, I don't know what we can do to get this forward. I guess who in town has this capability of making that happen?
Let's walk through Chris's memo, and hopefully that will help us to advance the discussion. Chris, I'm gonna, oops, Ron, can you give me the
Sorry.
almighty control? Please.
You should have it.
Okay, thank you.
Sorry.
Chris, can you, I'm gonna just, I'm gonna make this bigger. So, can you just kind of walk us through your, without
Yeah,
reading it
sure.
aloud, but,
So basically, the currently in the zoning bylaw, there are a number of provisions for how large projects, residential projects, can be permitted. And they're all pretty much the same, except, so I'm not going to go through them right now. One of them we actually deleted from at the last town meeting. One of them, special permit site plan review, Mark Bobrowski says is unconstitutional or something, so we can't do that. Because if you're allowed to do a plan by right, you can't then require a special permit. You can do a site plan review separately, however. And then the final one is the residential conservation cluster. And the cluster, the way it's currently set up, says that you're not allowed to create any more units than you could under a normal subdivision. However, you can relax the rules, reduce the size of the lots and the setbacks, and therefore reserve some open space. And so I guess we should maybe just look at some graphics as to what that would look like.
is that this?
Yeah, there we go. So that's just some dice sitting on a piece of paper. And actually, Gary Gilbert has done a much better plan than this. I was just trying to do something quick and easy. But the difference between the one on the left, which is a traditional subdivision with a single family house on a standard lot, versus a clustered where you can put units closer together and create open space. That's better for the developer and it's better for the town because we get much less disruption of the natural environment. We get some open space and theoretically it's better for the people living in the community there as well. There are examples of this all over town. So it's not like it's a brand new thing that we've never seen before. A great example is on Brook Street, across from the old Cricket Press building, where there's a wonderful set of townhouses on, I don't know, maybe 2 acres of land altogether. It's quite dense, but it's very attractive. Another example is at the corner of Pine Street and Bridge Street on top of that rocky hill. There are a bunch of clustered townhome things sitting up there, very attractive, minimal disruption to the environment and a great place to live. So the difference, what Mark Grabowski is proposing, one of the things in our current subdivision, our current cluster, conservation cluster, is that a certain number of units have to be set aside as affordable. And Mark says that that's been found to be illegal to do that. That what we really have to do is create some kind of a negotiation with the developer where we can trade extra density for goodies that we want. So there are 3 examples of that that are outlined in the new proposed conservation cluster. One would be trading more open space for more units. The second would be actually some amenities, some public amenities like a ball field or something in return for additional units. And the third might be affordability. So you could get more units if some were set aside as affordable. There's a limit as to how many more units you can do. So I think the current proposal is 20%. I'm suggesting maybe 30% if they're affordable. The rest of it is pretty straightforward. So I guess I'd open this up for questions from other board members.
Can we just, can I just walk you, can we walk through the rest of this memo though? Because I think you've done a good job of showing the proposed, so we have the existing provisions and the yellow here are the, so is this the existing bylaw?
Yes, that's the existing bylaw. Yes, yeah, this is the existing bylaw in yellow.
And then the yellow are the places that the new proposed bylaw changes.
So Mary wanted to see a track change, and it's very hard to do that. But what I was hoping to do is this is sort of a substitute with that, making the highlighting the important parts of the bylaw in yellow, and then doing the same with the new language below in green.
Okay.
Oh, and you know what? This isn't the reservation. This is not the conservation cluster. This is different. I went through each one of the different open space planning.
Okay, so this is the one you suggest that we delete, the special
Delete.
provisions. Okay,
Yeah, just delete this. Yes.
okay. And then the open, let's see. And the second one is the site plan review.
Site plan review
This is the
special
one that's
permit.
illegal.
That's illegal. So we're going to delete that. We should delete it.
Okay, so this is all related to section 6, those 2 things.
Yeah. They
So we would
all are,
delete
actually.
those 2 from section 6. And so the draft section 6 has those 2 things deleted, I believe.
Yeah, I believe that's right. They do. So
Okay.
this is the new 9.2. This is the existing residential conservation cluster as it currently sits in our bylaw that we changed in November.
Right, so it got renumbered.
Got renumbered, but it's otherwise the same.
Okay. So then the green here that you've added is indicating the things that are changed in the proposed new.
Well, they're the highlights of what the current conservation cluster does for
Okay.
comparison's sake.
All right, so then we go to the new,
We can go way down, way down.
way down, which is what we want to try to talk about.
Yeah.
Sorry. Here we
that's
go,
all right.
proposed
There we
new.
go. There it is.
Okay,
So you can see right away, it's the same sort of language about what we're trying to do with this. Greater flexibility, creativity, design, permanent preservation of open space.
okay,
And then, yeah, maintaining traditional character, land use pattern, all this stuff.
need to remember that. So all good things, diverse housing opportunities. The one thing I was going to point out just here is that the diverse housing, if you use the Brook Street cluster, I'm not sure it's a residential cluster or if they got open space, but one of the things is that when you do a cluster, sometimes you kind of by definition, by the way you can cluster the houses, you end up restricting how big they can actually get. And that therefore creates, one could argue, a less potential for crazy house prices. It,
Yeah.
so you kind of
You're
create that little,
encouraging natural affordability is what you're doing.
right.
By the way, some of these changes in here, we actually had a public workshop and some people actually provided some very interesting comments, and these I've captured in here, and this encouraged more sensitive reuse of qualifying sites in the RD1, RD2, and G districts. That was a public comment. So I included it. I thought it was an interesting thing.
So to the point that we've had comments on this before, Chris went through and tried to actually include those comments. So now that we get to the actual procedures, performance standards, development plan, and then in terms of the substance of the, these are sort of understanding the site, evaluating the site, location, and then here's the modifications of lot requirements. So this is the substance of this, right?
Yes, that's correct.
So why don't you just walk us through this?
So let's see, the first is that individual lots within a reservation cluster don't have to have frontage on the street other than a street created by the residential conservation cluster. So I guess that's pretty self-evident that you can reduce by 50% the side and rear yards that are required in the general district. One of the things we might want to consider is allowing townhomes in these clusters, which does also happen throughout the town, and it's probably a really good way to create even additional open space. But here's the key thing, which I want especially Mary to understand. The maximum number of dwelling units allowed in a residential conservation cluster shall not exceed the number of dwelling units that could be reasonably expected to be developed on the site under a conventional plan. So we're not increasing density on its face with a cluster.
Okay.
We are offering density bonuses. And the way the language that Mark has proposed to us is that the density bonus shall not in the aggregate exceed 20% of the maximum number. So if you're allowed 10 units under a traditional cluster, with the maximum density bonus, you get 12.
Okay.
Let's see. So the one way to get this is the bonus is to increase the open space by at least 10%. And the second way is to provide significant amenities to the town, including infrastructure improvements, equipment, technical assistance, whatever we want to negotiate. This is all under a special permit, so we have complete control over what it is that we want to get out of it. And then the third is the affordability component. And again, this is negotiable, but instead of just getting cash like we did with Surfside Village, that we want to get units built. And so we could actually add an additional 10% of all those units if they were affordable.
Is there any cap on the additive nature of these things?
So each one is 10%, but yeah, no. So if you did the full enchilada, you got a ball field, an additional 10% of open space, and an affordable unit. You get one extra unit, so there'd be 13 units out of a 10 unit cluster that you could do as a bonus. And we may decide that we don't want to do it in any case, in which case we don't grant the special permit.
So they're not additive. They're, the maximum amount is the 20% above, density bonus shall not in aggregate exceed 20%.
Yeah, that's right.
Okay, so if you got two of these three things, or even three of these three things, the maximum density bonus is 20%.
Well, that we can discuss that. And if you go down a little bit further. Well, so, yeah, I guess that's something we can talk about. And a minimum of 20% of a cluster anyway has to be contiguous open space.
Okay. And then it says that if it's wetlands, it has to be 50%.
Yeah, and it has to be used for specific things, and there's a whole bit of language about who can own it and what you can do with it.
Okay. Is this buffer areas new?
No, that's just a highlight.
Highlighted, okay. Okay, so comments on this new residential cluster, specific comments on the content and suggestions. I like that. Thank you, Chris, for putting this together and for incorporating the public comments from before. Mary, go ahead.
Thank you. Thanks, Chris. So I feel like this is what we talked about a few meetings ago, and we left that meeting saying we need some data to kind of look at things. So, you know, District D is going to be different than District C with this type of thing. Does it make sense to have it in District D? So we were going to look at things spatially and in a table in each of the district. So we would be informed before we brought this to a public hearing. How many lots do we have in town? So the current requirements are 5 acres. And now we're reducing that to just 2 times what the district requires. So how many lots do we have that in town, right? Like how many lots are twice what the district requires? So I think we should know some basic data so we even understand how many of these we could have. The setback requirements changed. The formula for maximum for the what is coverage has changed. The parking rules had changed. The contiguous open space, the current bylaw is 60%, the proposed is 20%. The buffer could be reduced. So it's all the same data we already looked at. So I guess I'm you know, would still like to see those samples, have us do some studies, some due diligence, so we have data. I feel like we're pushing a lot of these bylaws forward. And I think the reservation conservation cluster is a good thing, but I think we have to understand what our town is capable of, what are the lots that we're dealing with. I mean, we need to know data. And I'm sitting here and you know, the bylaw looks okay, I guess, but I don't know in real life how it translates to Manchester. So that's those are my concerns.
Okay.
So
go ahead, Sarah.
yeah, I was gonna say, I think that data is challenging to put together. And the outcome of of a build out analysis, which is what I think you're asking for under this bylaw versus the old bylaw, is kind of the maximum numbers of units that would be, if everybody who was for whom this was a possibility did a maximum build out. That's the question I think you're asking. And then,
No.
but so what's the outcome of this analysis? What's the question that we're going to answer with an analysis? So maybe we can get at the question in some other way. What's
Yeah, no, I'm
what's the
not-
outcome we want to know?
Yeah, I'm not looking for a full build out at all. I mean, I think with our current bylaw, you can quickly determine, okay, how many pieces of land are 5 acres or more, right? Like that's pretty easy. You're gonna rule out probably all of District D, lots of District B, you know, so you're only getting to certain districts. So when you take that requirement away, you kind of say, okay, this could happen all over town. Is it the same, you know, does it have the same impact in a District D that it would have in a District C or E or general district? Or, you know, we have to be able to at least plot and plan a little bit to say, does it make sense? And I think the example I said last meeting was District D, where you could get, with the bonuses and things like that, 5 houses on 12,000 square feet for a payoff of what open space? Like, you're not going to have any open space left, really, right? Like, the percentages
So
don't really.
so Mary, that's the point. You can't do that. You have to have the open space. What you're doing is taking all the open space in everybody's yards under current zoning and then putting them all in one corner and saying, that's everybody's open space. And it's got public access. And everybody else is living in much smaller, with smaller yards. That's essentially all you're doing. So the data is, there's no change. There's really no change except for an occasional density unit here and there. But just like Surf Village, those all units could have been all in a subdivision, all with their equal yards and equal 3-family houses. But instead we allowed them to be lumped together to make it to provide some open space as a result. So
Yeah, and again, when you require 5 acres, I think that makes sense. I'm not seeing the data that it makes sense for these smaller lots. I just don't see it.
But there is no data. That's the point. I mean, if you have a 1 acre unit, 1 acre piece of property, you could do, I guess, 4 units right now in the D district, right? I think that's probably right.
No, well, 12,000 square feet, you could do.
How big- What's the minimum lot size in District D?
Oops,
You
you're
could
breaking up.
You could do 5,000, you could do
Okay.
5 units on an acre.
5 units on an acre.
And there are acre lots in the D district,
There are. So that's under current zoning. So
and they
how many
could
could you
be
get under?
subdivided.
If you subdivide them, you could have 5 units. So how many could you get with a cluster? 5 units. There's no change. You get the same number of units. But if you want to do something special, you can get maybe you get 1 extra unit. Maybe you get 6 with a bonus.
The maximum you could get would be a 20% bonus, right? Because 10
Yeah.
plus 10. So
You get
said
one
the
extra
max, you
unit.
could get 1 extra unit. So if our concern is growth, then then there's if growth is bad, then this does have bonus for certain other values. And if our metric is growth as a good or bad as a metric, I mean, I think it depends on your perspective whether it's something we want or not, and that growth comes with a corresponding public benefit that's enumerated as affordability, preserved open space, or other public benefit. So I think the question is philosophically whether or not that's a good trade-off and it's kind of impossible, I think, to determine where people will take us up on that. Because we know that there are many places in town that aren't fully built out under current zoning, so that current zoning is not a predictor as of today on what a full build out would be. Does that make sense?
Yeah, and I mean, I don't want to keep beating this because I'll argue it all day long. I mean, I think what Chris is saying is that, well, you know, you could do 4 or 5 units now in District D if you had all these little parcels of 6,000 square foot pieces of land, but that's not how things work out. You're not going to get a 6,000 square foot lots in a row with frontage, right? Like there might be these one-offs where you've got a 12,000 square foot lot, you have frontage on one street where typically you wouldn't be able to,
I think you would do
divide it because you don't have the frontage, but this is going to change that. And so, you know, but again, I would like examples, I guess, is my key.
So that the example is if you can reasonably get 3 units on a lot in the D district by right, that's all you can get with the cluster.
But you can't by right now.
Okay,
Yes,
let's.
you can. Of course you can. If you have the frontage and you have the lot sizes, you can subdivide. You do A&Rs all day. You can do it.
Sue has her hand up, and then I want to speak to something on that.
Thanks. Mary maybe is missing the point that if you have that lot, you can create a subdivision by right, thereby it creates the road, thereby creates the frontage. So that's the mechanism that would allow you to divide a lot. We're just doing it in a more efficient, effective way and getting a benefit from it.
With special permit review.
Right. No, thank you. No, I understand that. And I guess I need some analysis or something that this is the best, most efficient way for all districts, because it's a big change from what we currently have. So that's all I'm going to say.
I'm going to take Laura in a second. I just want to point out that having spent 7 years on the Newbury Planning Board, where lots of what everybody would have said was a single family, one lot, one house lot, ended up getting subdivided with these crazy pork chop lots, which might be harder to do in Manchester because of our lot width requirement, but nonetheless, and these cul-de-sacs that went in, and it's quite amazing what can be done with subdivision. We don't see a lot of them here, but I think we want to avoid those things that end up being these crazy subdivisions. So, but I have a second thought, but I'll come back to that. Laura, go ahead. You just moved.
Yeah, I'm trying to think about, and we're talking about number of units, and that's certainly important, and it's one of the measurements, but I want to make sure we also talk about this in the terms of kind of environmental conservation and the footprint of development. So if we're looking at residential clusters as an opportunity to preserve land that does have public access on it, so it's not simply for the the residents of 4 or 5 townhomes that you might create, but are actually preserving land that's providing stormwater benefit, flood control, public access, wildlife corridors, perhaps, or whatever the other benefits are that we might decide. I think we should just talk about that at the same time that we're talking about the units, because the units are the same until we provide a density bonus that gets us something above and beyond, say, an affordable housing unit. But I wonder if a way that we could address your concern, Mary, would be looking at some examples that are that already exist out there in terms of the physical space efficiency of residential cluster. And I'm sure you're probably familiar with these, but if we haven't produced them for a lot in town, I think there are good examples. And no disrespect, Chris, I think your diagram is not doesn't count, because the 5 houses grouped around a cul-de-sac is not what I would call an example of great or creative cluster
No
zoning.
offense taken.
Okay, so maybe we can look for some of those and bring them to a meeting where we say, here's an example of what we're striving for with our residential cluster. This is the sort of vision for it, and here's what 5 units looks like this way, and what 5 or 6 units looks like another way, and the environmental benefits that you can realize there.
Can I
So
suggest?
the planning board has approved 4 of them in the past. There's a Surf Village, Summer Wind, Cross Toe, and then there's one on Lincoln Street,
They all had 5 acres.
on Pleasant Street. Yeah, so if you want to look at them,
Mhm.
they're there. They went through special permit review.
So it seems to me that there's some agreement that we should move this forward to which is where I'm trying to get to the town meeting, to the public hearing, and hear input on some of these issues. And that perhaps the 2 areas where there's a little bit, where there may not be unanimous agreement, maybe there's majority agreement, I don't know, is what the minimum size for these, as we move from 5 acres down to something smaller, that is an issue. And the second issue is what the density bonuses should be. The maximum right now being proposed is 20% density bonus for those attributes. There would be the possibility of making it a maximum of 10 or maximum of 40, I don't think anybody's saying 40, but it seems to me that those are the 2 big issues here. And that that Laura's idea of maybe drawing a few scenarios, and I would ask maybe Mary that you take and make that table with some specific scenario that you, under the current law or zoning, what would be allowed and what would be a residential cluster would be that plus the maximum be 20% under the current proposal. And it seems to me that those are the 2 issues really with this proposal. Are there any other major issues? There's some finer points, but are there any other major issues that people see with this residential that are disagreements? Mary?
Oh, I just lost my train of thought. I guess what I would say was, one, we have examples of it in town, but I would like to see examples with the changed bylaw. Again, those were done under a 5-acre rule. I don't have the capacity now to put those numbers together. So I'll take my name off of that. And I think if this is brought to a public hearing, I think we should, and any of the bylaw changes, really, we should look at it in its entirety of how, residential conservation clusters would work with accessory dwelling units, would work with revised curb cut regulations, but, so I think we've kind of siloed everything, and I think and I don't know if this happens at the end, once we've had public hearings on all the separate things, but I think we should start to encompass how all of it would look. Just my thought.
I'm not sure how we do that. If you have a specific idea about how, I'm not sure I understand what that looks like.
Yeah, so even a question I would have is it, say on a piece of land, a residential conservation cluster goes through, does that mean there's no accessory dwelling units allowed on that? Just because it's now a conservation cluster? I don't know.
Mary, so Mary, a conservation cluster is a different way of doing a subdivision. We have a subdivision control law in effect right now. And this is basically a variation on the subdivision control regulations. The subdivision control regulations say nothing about accessory dwelling units. They don't say anything, they specify curb cuts, all that's gonna stay the same. It's all controlled by the subdivision regulations. All we're saying is that certain provisions in those subdivision regulations can be waived under a special permit that allows the units to be clustered together more closely than they would under a traditional subdivision. Maybe that's the way to think about this.
No, and I understand all that, but so maybe I missed that part in the subdivision, but so accessory dwelling units are not allowed then?
Of course they're allowed. They're allowed anywhere.
Okay, so then that just like that type of example. So again, if
Well, today they're not allowed unless you have double the lot size. But if we were to modify that, they would be allowed.
But that doesn't change anything. That doesn't doesn't make a cluster more or less
More.
beneficial to the town.
Okay, Laura, you have your hand up and then I want to do two things.
Okay, it was just a question about where in the language do we talk about the publicly accessible benefit? And I just want to make that clear for perhaps at the public hearing that we are entertaining
I think it's
cluster.
the density,
for that reason.
it's the density bonuses. There are three.
Well, there's contiguous.
Right, so it's contiguous open space of 10% of the site over the open space requirement. So,
But how do we say,
you
does
can get-
contiguous open space mean that it's publicly accessible? And who decides whether that benefit is met?
So if you go further down, it talks about ownership and use of those. There we go.
Okay, here, contiguous open space, minimum of 20% of the parcel shall be contiguous open space. Any proposed open space, unless conveyed to the town, shall be subject to a recorded restriction. So I think the idea is that it's not necessarily, in this case, is it necessarily open public to the public? I don't think that's specified.
No, I guess we could add it.
So maybe the bonus should be for publicly available open space.
Sure. I think that's the intent.
Okay.
I would disagree that it's always the intent. I think neighborhood open space in most cluster bylaws, it allows it to be owned and used by the residents of that neighborhood as well. I think it's helpful.
Not
or
publicly
could be,
accessible, Sue, or?
and not necessarily public accessible. In fact, some of them are not accessible at all and are only used for conservation purposes. I think it's really dependent on the site whether it's. I would be hesitant to say it has to be open to the public because I think there are many ways that we can benefit from green space without the requirement of open to the general public.
Maybe we could add wherever possible, public access shall be encouraged or something like that. You know,
I think we might get into a liability issue there.
Well, if it's conveyed to the town, then obviously the town has a right to use it for that purpose. And I don't want it to be a disincentive, certainly, to cluster zoning, because I think just the smaller footprint of development is a benefit in itself. But
Well, I think maybe it's when we're getting into the bonus situation that you make it a requirement.
Yeah, that could
Sarah,
work.
I don't have it in front of me. Mine was numbered differently. I had 9.2.14.3, but
Should be 9, actually.
Yeah,
they,
this might be
it
an
said
earlier version.
the town would maintain the open space. So is that still in there?
No,
I don't think we took that out.
You took that out?
Yeah.
So do we, I'm getting so confused. Do we have any track changes from what we talked about 3 weeks ago to now?
I think this is what we talked about 3 weeks ago. Okay, let me stop. Let's do 2 things. I think we're going to need another workshop both on 6, the very specific things on section 6, and the issues around the most current version of the residential cluster, which I am going to put in separate from Chris's memo. So it's the residential cluster proposal. And I think that largely we're talking about, if anybody wants to try to gather some data, that's fine. But we're, as Chris has said, the question really is how big, how much density bonus would we offer for these public goods? And, you know, I think it's the numbers that matter, right? Is it 20%, you know, open space, or 30%, or, you know, what are those public goods that for which you get a density bonus? It seems to me that those are the important details that are substantive, and we're going to have to call out and make some just decisions on those, I think. And I think they can be enumerated in a short list. So we're not going to try to, I would hope to try to get through those tonight, but I don't think we have the bandwidth. And I think we can pull them out and get the actual, I can put up a new version of the right version using this memo, cut it out and have it as the language. Christine?
Is there a copy that hasn't been changed that we can compare to what we're changing? Like, how are we keeping track of this? Like, I feel like some things are changing, not in a meeting.
Yeah, that's a good question. In the SharePoint directory, I have put the latest approved changes of everything. So except for section 6, the residential cluster and the accessory dwelling units, we have voted to move everything to a public hearing. Now, arguably, they're not perfect, and I think we need to go, and we last time authorized Chris, Mary, and me and Sue to sit together and do the administrative section numbers and, you know, little picky things. We're trying to figure out a time to do that. We don't have a track changes document, and we're not, I can't possibly imagine doing it. I can't imagine that it would be useful. And I worry that worrying that change is bad is, being scared of a change is not necessarily helpful, but we should look and read carefully the proposed new language to make sure that they are moving us in the right direction. All of the changes that we have put forward have had a lot of vetting, either from Mark Bobrowski or from prior public comments. No, we don't have a track changes from our existing document.
Well, I just can't read the document to see what was changed every meeting for specific changes to see what was happening. So I think the track changes are helpful to save time. I guess I don't have the amount of time to compare new to old, and
the only documents that are in there that, except for those 3 that I just listed, we voted to move those versions.
Okay, but like
forward.
Section 6, the rear parking out, that was taken out, but we didn't discuss that. We didn't vote on that. So I guess that's
You're right. We have not voted that, and that we need a workshop to go through section 6.
But why was it taken out is my point. Like, we didn't, to me, it shouldn't be out regardless. So until we vote and talk about it, it should all be in there. So I guess I'm concerned about keeping track of this and just removing things without a workshop. I mean, it's gone.
It was, I think on section 6, as we described last time, it was an effort to try to make sense of what's a scramble in that, and to move toward best practices. So if you feel strongly that there are things that have been taken out, I think we have to lay them side by side. You're gonna have to lay them side by side. So that, I don't see another way to do it. And
I guess where's the original document then?
the document is in your zoning.
All the drafts are on the SharePoint, every draft.
So that was actually my question. So the draft that we talked about last week is in there untouched versus the draft that now it's removed, backing out of the driveway?
I don't know what you're talking about last week.
Last time we did review section 6 and I tried to keep the same version, I think. So,
Yeah, nothing's
Yeah.
changed.
so let me ask
Has
one other
changed.
question. Let me ask another question. What I need personally is actually a printout now of all of this. And I wanted to know if others would like, I'm gonna work with Sue or somebody or Sharon or to get a printout of all of the latest, the near final or draft versions. Does anybody else would like a printout while we're getting one for me?
A printout of which section, Sarah? All of them?
To
or-
do all of them because I need to lay them on my dining room table and track changes
yeah.
with pen to make sure that the section numbers are correct and that they have, Mark Borowski had different
Yeah.
numbering and all those things. So
So a printout of all the proposed new language.
yes,
Yeah.
I'm gonna do
That
that
would-
for
that would be
myself.
helpful.
Is there- Chris, I know wants one.
Please.
Mary, would you like one?
Yes, please.
Christina?
Yes, please.
Gary? He's away. Ron, would you like one? Or are you happy? No, okay. So we've got 5. Great. I'll work with you, Sue. I think we need another workshop. It's late, getting late. I haven't eaten dinner. I don't know if anybody else has. Do we want to have a workshop before town meeting or the week of town meeting? Those are really the choices. That week of town meeting is school vacation.
So the
No,
week-
I'm sorry.
Vacation is next week.
Next week is school vacation.
no.
I would suggest one before, because we could also maybe go over the presentation for the LCD at the annual town meeting, or unless we're doing that tonight.
Actually, I need to sign off.
Ron,
in a
can
minute.
I ask you a question on that?
Let's figure out
Yes.
where we're gonna meet if we can. So that I think that leaves us with Thursday night this week. Or Tuesday or Wednesday next week.
This is a workshop or a planning board meeting?
It's a workshop to talk about zoning.
Which must be a planning board meeting, so it must
Which is
be
gonna be a planning board meeting.
posted, so that's a problem to be too quickly.
Do
Yeah,
you
we-
want
I'm
to look
actually-
when, you want to
Is there
look
any
when
chance
other
we could
town
do it on the
meetings are?
21st?
I'm sorry. So we could
Next
do it.
Thursday, a week from Thursday. I'm actually doing some college visits and won't be back until late Wednesday night.
So
You may
I'm
want
not
to look when
available on
other
the
town.
21st.
I'm sorry, Laura.
I'm sorry, I'm not available on the 21st.
How about the 26th or the 27th? Is there anybody who can't make it on either the 26th or the 27th?
Sue Brown and I cannot make it on the 27th. There's a 40B meeting.
I was gonna say, I prefer the 26th.
I
can
could do
do
the
that.
26th, like, yeah.
Okay, town meeting is the night before, so. I think I'd rather do it after town meeting personally, but. All right, let's try for the 26th. But-
Sarah, are you anticipating a Zoom meeting?
Yes.
Okay, thanks.
Did
I'd
you
rather
want to
do it-
move it to 5:30?
Sure.
I won't be on
Is that
before
a problem?
6:30. Yes,
Yeah, okay,
Sorry.
6:30. Mary, did you have? Okay,
My hand was up from before too, but Ron, you mentioned LCD. We still have not yet presented the LCD bylaw change to FinCom.
Yes, we
FinCom's
did.
approved.
FinCom is, I've talked to Mark Weld on it. They've gotten, they actually approved. They went one step further and going to endorse the LCD plan.
But a few meetings ago, we agreed that we needed to present it to FinCom. What happened?
Mark Weld was a liaison to our meeting. He was put there by Sarah Mellish. He attended our meeting. He heard the testimony on it. He reported back to his FinCom, and it was all taken care of within their own group.
So he did it at a FinCom meeting?
Correct. And then they approved, they voted not only to, they voted to endorse the use change.
Okay, I'll check with Sarah.
Did you attend that meeting as a liaison?
I have not been at a meeting where it was I was at a FinCom meeting where cell signaling presented what they wanted to do in the
Okay.
LCP, but not what the bylaw change was.
Yeah, so Mark Weld has been named liaison to our group by the FinCom. So now we have double liaisons. So we need to sort out with Mark and you as to how we're going to handle that.
Yeah, because I kind of thought our bylaw said that the planning board should present to FinCom, but I'll check on that.
Okay, Ron, I'll turn the chair back over to you.
Sarah
we're done
and
with-
Ron, excuse me. I'm sorry, I actually can make the 5:30 time on that Tuesday work. Just want to let you know, I was just looking at my calendar that day. If that makes it easier for the rest of the board.
I think we can get out earlier. I would
I'd like to
advocate a
believe that, I'm not
5:30.
sure I do.
Is there any chance we could do that in person? I mean, it just feels like it would be easier to sit with pieces of paper and.
If it's a public meeting, I don't know how to do that yet on the technically how we do that in town hall.
Ron,
We're
you may
supposed to get
be
training.
able to ask Tiffany or someone to provide assistance with that, Tiffany or Sue Croft or some others that have been trained and
Okay. 'Cause
possibly
I didn't know if there was going to
given a
be
little
a
bit of notice.
laptop. Are they providing a laptop to us to, broadcast
under-
out? I mean, there was some questions, so I'll follow up with that.
Ask for room 5. I understand that's technically much easier. It's like opening your laptop and.
Okay, well, I'll let you know.
Does the board, have we decided at 5:30? Is that kind of what we're saying for 5:30 on the 26th?
Yeah, that's fine. Oh, Ann Harrison has.
Ann, go ahead.
I was at the training. There is hope that room 7 is simple. Room 5 was not at all simple and would require technical assistance from Comcast and good luck.
Well, let's
Room
just meet on
7.
Zoom then. Let's
But
meet on.
thanks for clarifying. I got the wrong message, I guess. Thank you, Stan.
Okay, so tentatively, it'll be in person if I can work out the logistics. Otherwise, it'll be back to Zoom.
Okay.
Okay, so the hour is late. We've been at this 3 hours. I just wanted to, the planners report. Does anybody have any questions for Sue on that? It was pretty. Mary?
I had a question on the downtown parking study. It says that Downtown Improvement is working on a survey for businesses and multifamily rentals. Why would they not be doing a survey for all residences downtown, whether it's single family, owner occupied? Why is it just businesses and multifamily rentals? Yeah, that's my question.
I guess you would have to ask them. I don't have an answer what they or why they did just multifamily.
Oh, okay. I thought you went to those meetings.
No, they've been, unfortunately, they've been in conflict with staff meetings, so I do
Okay.
not get to go to all of those.
Do you know who the chair is of that board?
Steve Carhart.
Carhart, thank you.
Any other questions on the planners report? Mr. Laura?
Curious to see what happened to the forester on the,
Oh, yeah, thank you. Thank you for that question. He didn't seem able to complete, he's gone a bit radio silence after the first week that he was employed. I have found another forester from Western Mass. He's the same one that did the conservation or the baseline report for Christian Hill. He's assured me that he's done these numerous times and he could do it within the remaining time that we have. So I'm hopeful that we'll be able to secure his services and move forward with it without too much of a hiccup. Yeah, it's unfortunate. I know
Yeah.
he's had many personal challenges that just didn't allow him to move forward with the work that he wanted to do.
okay, thanks.
Thanks.
Just a general comment. I find your planning board updates very informative, and I hope that after we get through all the zoning stuff and the updates that we're doing, that we can go back to kind of having you present those to us and talking about it a little bit more. I know we don't have the bandwidth right now, but I think they're valuable. So thank you.
Thank you.
Okay, I think I'll skip the subcommittee and liaison reports, and I just want to get some of these minutes off of our, they're in a backlog here. We got 2 months worth. Any comments on the minutes? Let's start with 2/8/22. Maybe we should call them up. Mary.
I have to find them now. I actually had a question on the town planner's report about blasting, but we're not doing anything about blasting this go around, correct? For recodification.
If the question is to me, I've offered recommendations. I did note in the planner's report, the Board of Health didn't have the capacity to change and step into that as Christina had suggested some language that they do. I think it stands up on its own without that, but we haven't created that's not a zoning change. The zoning already exists. These are internal regulations that we would promulgate and post, but it's not a zoning change. It's sort of like a policy regulations that you can create by your board, is my understanding. The zoning is already in place. Sarah, do you agree with that?
I would just have concerns that we're not doing something that's part of the safety because we don't have the capacity at the moment. It just seems like this section they're recommending taking it out because they don't have the time, yet it seems like a big safety issue. So that was my comment?
Well, I guess the board can decide if that's an important part of it. My feeling, it wasn't in the original. It was something that was pulled from another community. Very few communities have any regulations on it since it is handled by the state. I think that the intent, overall intent of it is to provide greater transparency and greater amounts of information regarding blasting. I really think the safety is likely in the hands of the state, but that's certainly a board's prerogative to ask for further changes in that document.
Ron, may I ask,
Yes,
I was going to ask that we just get these blasting regulations onto our next meeting and finalize them. They've been out there for almost a year. Let's just vote them. And if we can always modify them as the Board of Health has capacity or whatever, I think we've got a good draft, and let's vote them at the next meeting. I think if we've, they've been out there, we've been looking at them for a really long time. So. And then I do have comments on the minutes.
yeah, so yeah, you had a lot of comments on February 8th. I see them all in the side there.
Yeah, so I put them in the comments. If others have comments, I can add them as we go here too. I've been trying to keep my comments very much to the motions and not worry too much about the other stuff, because
I just had a few from February 8th.
Go ahead, Mary.
So page 2, the first sentence says Ms. Gilbert instead of Mr. Page 3, 3/4 of the way down, accessory uses, it says accessory uses are in subsection E of the use table. I didn't know what subsection E was, but
just say delete the subsection. Where's that?
Page 3, about 3/4 of the way down, accessory uses. And then just on page 4 where it says Ms. Foley asked about the floodplain and why aren't we doing it? DPW has one that is already, it should be 2 separate words, already. That's it.
Sorry, I'm still not seeing this section.
Oh, on page 3? So there's
use table.
It says indoor club or recreational site, and then there's accessory uses.
Oh, why do we leave the narrative? Can I just strike that sentence?
Yeah, that's fine.
Okay. Okay. So I'll move Laura has.
Yeah, I made comments by email to Sharon, only the ones that I thought were really substantive on my part. I don't know if they made it through or not. Do you want me to just read them here? Okay, so 2.8. Let's see, I said, could we please add that all of this discussion beginning with discussion ensued regarding yard versus construction yard, all the way through until discussion ensued regarding swimming pool by rights. That should all fall under the topic of definitions. It was really not clear that to anyone what we were talking about. And then there was one sentence in particular that I wanted to clarify. Just tell me when you're ready. Or if it's easier, these are also in an email, Sarah. I can just do them live for you. I think all we need is just a heading that says zoning definitions.
Yeah, okay.
And then there was one sentence that I just want to clarify. So it begins, impervious surface was discussed with LCD. strike with LCD. And then it says Miss Tenney suggested not using pervious surface.
Yes, I caught that one already, and I
Okay.
already gave her that. I gave her written comments on this.
I did too. I just said I did not suggest using pervious surface in the definitions because
Right.
impervious surface is what we were trying to define. And I thought the meaning was entirely unclear as written.
Yeah.
Okay.
Gave
And
her
then
that comment already.
Yep.
I printed it out.
And then I have 214 and 228 if you want. And again, it's like one sentence on each.
Okay, so should we take a motion? Ron, can I make a motion to approve the minutes of February 8th as amended?
Second,
Sorry, I was making.
roll call. Ms. Creighton,
Yes.
Christina's left, Ms. Foley,
Yes.
Gary is left, Mr. Olney,
yes,
Ms. Tenney,
Yes.
and chair votes yes, so it's 5-0.
And can I just ask, is Gail able to make these changes from on the document, given the changes? Is that? I mean, they're on the SharePoint meeting folder for this week and they have the changes reflected in them, but they need a final version. And
Let me
somebody,
see who, let me just figure out who needs to do the changes.
right, or Sue
I
and
would prefer
Gail.
not to, I would prefer not to change someone else's document.
Well, they got to get finalized somehow.
Well, Sharon is still the admin for planning board. I
If it-
am
I
doing
can- You're doing them going forward, yes?
minutes, yes.
Yes, the minutes. I can pull them off and give them to her. My understanding is that she has access to them, so.
I provided
We'll
my
get it
comments
done.
multiple
How
times
about-
in
how
writing
about that?
to
We will-
Sharon.
We will get the
Yeah,
edits
so have I.
done.
Okay, 214, I'll pull up.
Sarah, and Laura, were the suggestions that you made, Sarah, have you already put them in the minutes or were they just in an email that outlined where they
Mine
were?
were in an email
Yeah.
written to Sharon when I copied Ron, Sarah, and you, Sue, and I can give you the dates.
Okay.
Two of them, one of them was sent on April 4th. That was regarding the 228 minutes. And then the other two were sent on April 7th regarding two separate emails regarding 214 and 208 minutes, February 8th and February 14th.
Okay.
Three separate emails, just like one sentence each. But
Okay. And Sarah,
Thank you.
were your changes made within the document
Yeah,
that's on SharePoint?
for now, yeah, I guess.
Okay. And did you just make the ones, the ones that Mary offered? Did you put those in that
Yes,
document?
I did, as well, but mine were put as comments.
Okay.
Okay, Ron, is it okay if Laura gives us our changes now?
This is on 214.
Yeah,
214 on the decision, the motion that begins for
Yeah.
pedestrian safety. The area of the sidewalk that is raised needs to be repaved, strike smoothed down at the applicant's expense to comply with MAAB accessibility standards. Not safety standards.
okay, needs to be repaved to comply with
MAAB accessibility standards. And we discussed in that meeting, it was at the applicant's expense. That did not make it in the motion.
She did change.
Laura, what's the standard you're referring there?
MAAB, Mass Architectural Access Board, accessibility.
Thank you.
Thank you.
Okay, I think the repaved did get in there.
Okay.
So Ron, you want a motion? Is that it on this one?
Well, there's,
You-
there's,
Do you want typo changes or just content changes?
There are a lot of typos.
Yeah.
I think we should just focus on people or content.
well, if you get down to the end here, about the, going to town council, asking Gary to go to town council, I think that's kind of a misinterpretation, this line here. Again, I think what happened, if you can go up a little, Sarah, on this, where it says, I think Christine said we should go to town council, and then I think we had Bobrowski under contract, and at the time, going to town council was a tedious thing, so I think Gary went to Mark Bobrowski for timeliness on that. I don't think I asked Gary to go to town council. I think that's incorrect statement.
Sorry, on what page is this on?
Keep going to the bottom.
Oh, bottom.
Keep going, way at the bottom.
The middle of page 5.
Oh, right there.
Yes, I also said we should note that the board go through the. Oh, I see. That was something different.
Because I think what happened is that the question went to Bobrowski,
Yeah,
not town council. So I don't know.
yeah, I think that,
That's
so
a
isn't
correct
the
statement.
point that the board has to go through the board, I delete
At the
that.
time that was asked, the board had to go through to
Yeah.
get permission from the Board of
Right.
Selectmen to ask a question to town council. So I think there was some urgency to get answers. So we had Bobrowski under contract, and
Ron, can I clarify that?
yes.
Yeah, so I have a discretionary fund for professional services. When I saw that the board was struggling with the A&R, I asked Mr. Bobrowski, and I let Gary know that, and I know he was trying to take a first stab at these A&Rs and provide comments. So I told Gary to put his questions together, and I would send them to Mr. Bobrowski, and not under the contract for the recodification at all. In fact, I was very clear with Mr. Bobrowski that this was a separate issue and that he should bill me separately for those services. So just like I am looking at those funds to do a zoning workshop on A&Rs, that is under also my discretion. This was completely discretionary that I asked him to do that, and I followed up with him twice to produce the document that he had in hopes that it would help the board.
The other thing is at that time, we had been waiting for 4 weeks for comments on the LCD changes. So I don't know that we need to put that in the minutes, but okay.
Can I
Any
ask
I
a-
would strike that. I would just strike that line.
Yeah. Stick with this one.
We need to explain all this.
Right. That was my original intent comment. Okay, other comments?
So do you want typos or no?
Mary, I'll proof for typos. I'll
Okay,
go
That'd be
through.
great, thank you.
yeah, because
No
there's
problem.
just, mixing up Ms. and Mr. and
That one's tough. I've done that a few times myself,
yeah.
but I'll find them.
Laura, do you have other comments that I should put here?
Only on the next set of meeting notes.
So I'll move that we approve the minutes of February 14th as amended.
I'll second.
Second. Anybody opposed?
Nope.
Oh, okay. Approved, 5-0.
Yep.
February 28th,
I had one.
go ahead, Laura.
There's a line that says, Ms. Tenney thinks we should not be given dimensional requirements. We need to obtain a professional opinion. My intent was we should not be providing. I think I might have said giving. That's it for me.
Any other comments on 228?
I was not there.
Motion to approve as amended.
So
I'll move that we approve them. I'll second it then.
Anybody opposed?
Nope.
Approved to 5-0. On 314, I have one comment.
Actually, Mary's abstaining
Yeah.
on that.
So it's 4-0.
I'm sorry, 4-0 with 1 abstention and 2 absent. On 314, it's like the second to last page. It says, Mr. Mastrogiacomo asked if the special town meeting on 6/11 at 1 PM and 6/14 at 6 PM. I don't know what that line means. But I think what I said was that the special town meeting will either be on 6/11 at 1 or at 6/14. So it should be, the sentence should read stated that the special town meeting would be on either 6/11 or 6/14, something like that. It should read.
And then I had
correct.
a,
What's,
Yep,
Yeah.
I'll fix it.
you're fixing it?
I
Yeah, it
have it
doesn't
from
make
the Board of
sense.
Selectmen.
I
Okay.
think the dates are correct and the times, it's just the way it's stated.
Yeah, and then other one on that one is that the roll call was in favor of laboratories and scientific uses. I can just correct it.
Where's that motion?
It's moved and seconded by roll call in favor of adding, can you see my screen? Laboratory and
And
scientific.
scientific uses, yep. Got it.
In the LCD, and then this,
I don't know. I wouldn't have made that motion.
I can listen and find out who made the
I
motion.
think it was 6 in favor and 1 opposed, Foley. Does that sound correct, Mary?
In the LCD east of School
no,
Street.
we all voted in favor of that.
Yeah.
Oh.
I don't know why Foley's there. It's my only question.
Just delete it.
Yeah.
Sorry to delete you, Mary.
It's quite all right.
Still not seeing that town meeting thing.
The right instinct in this case.
Oh, here. Okay. All right, move to approve the minutes of March 14th as amended.
Second. Anybody opposed? Okay, this one's 5-0. Okay, the last one, 321. Any comments?
Were they in the folder?
Yeah, I
See.
didn't get the review the last two from the last time I was able to look in the
No,
folder.
the one,
321's not in there?
Well, it wasn't in when I went and looked, when I pulled
Okay.
everything, which was.
So let's
Friday.
hold off on 321 then. We'll do that for our, we'll put that on the, our workshop, on our next meeting.
I think
Can
it's
do the
April,
4th.
April 4th. I haven't looked at April 4th either, but if others have, I can.
Ah, it's April 4th on there? Wasn't on the agenda, but
I
she's
know,
got them
Sue
in
and I
there.
got them done.
Oh, you did.
Okay. Does the board want to vote either of those minutes right now, or we should table
Let's table them.
them? Okay,
Change.
all right.
That's the last time
Thank
we
you
hurry to
all.
get those done.
Right. Yeah.
So the
Sorry,
next
I-
time we meet is April, May 9th. So annual town meeting is before us. It's in 2 weeks. Hopefully we can all attend and
You
we'll
meet
have
May
some kind
9th,
of
but are we also meeting on the 26th?
Yes,
April
and day
26th.
after town meeting.
Ron, are you going to send that to Sharon to post?
Yep.
With the
We have a little,
appropriate
I
agenda?
think post
Okay.
next, once we get these.
post. What are you talking about? Posting the
26th.
For the 26th.
26th?
Yeah, I'll forward that information.
Okay, thank you.
I'm in
Okay, but we
town
need
hall tomorrow.
to, and then we need to come up with an agenda, Sarah.
Yeah, and then we're gonna need to get the public hearing notices done for a hearing probably the week after that. The week after May 16th, or maybe the end of that week.
I'm
So,
gonna take a crack at starting that, see what happens.
Okay. All right, and
All
I'll
right,
try to come up
guys.
with an issues list that we can think about for each of these things. And really our goal is to get them to public hearing and get input on the matters. So it would be
Really,
strategic to make them, to make the issues as broad or so that we back them down, or, so the public notice is
Vague
approached
as
broadly
possible.
enough. Yeah. Okay.
All right, I move we adjourn.
I appreciate all the board is doing, in
Laura has
breaking
a-
this up into pieces.
Oh,
I want to just make a plea on the night we're starting at 5:30. And I, for one, am coming right off the train from Cambridge, that we're starting early. Let's give ourselves a clock and end early, like whatever we decide it is, 8:30, and then we're done. So we don't just expand to fill the evening till 10.
good idea.
Understood.
Okay.
I
And I'll
agree.
Thank
get
you.
everybody a printout somehow. I'll let you know.
Okay, great. Thank you. Thank you, Sue. Thank you, Gail.
Thanks.
Okay, a
All right,
motion to adjourn. Any objections to adjourning?
No.
We're adjourned.
Good night, everybody.
Good night.
See
Good
y'all.
night, everyone.
Take care.